498. Okay.
CRLMC 1605/23. It was directed to be listed on 24/2/2025, but somehow inadvertently it was.
What is the urgency?
Intro relief is there and the lower board of admission.
Let's see.
There is another one, criminal appeal 3/2024. Well, I have filed an IA. Please that may be taken.
IA for what?
I am not, this provisional pension has been stopped and this.
Oh, you are convicted.
But there is nothing in the case. It's convicted in the.
Give it to include that in the weekly list. If get ready.
I'm ready.
Anytime I can take it up. Okay.
Hardly take 10 minutes. Even if heard the topic.
But that 10 minutes I should get.
Yes. 482 application. File this case to what the proceeding on the basis of the compromise we made.
What are the offenses?
420 hours.
420.
The 3 applications there.
Not the builder. Are you a builder?
No.
Builder 420 is difficult. Okay. Yes.
Item 1 to 5.
Item 2. Sorry.
Yes.
Item 2, since I partnered my modified, Mr. Roth has provided me with a copy of that written note.
Item 2.
Item 2. And written note of submission we have filed on that. One has filed it. Not in response, no. There's not been a copy.
Let it come. I'll just take care of that. Mr. Morana has filed.
In fact, they have responded to not that and provided written note of submission.
So Mr. Morana has to read it. Okay, we'll see. We'll adjust. Yes.
Item number 1, my lord. On behalf of senior my lord, Mr. Deputy Minister, I pray for a short adjournment, my lord.
Interim order is there.
My lord,
2018 matter.
My lord.
Why adjournment?
My lord, some documents for.
I vacate it. I vacate the stay and you keep on filing. You took, see, 2018 you have taken a stay.
Any date, my lord,
On behalf of Mr. KP Mishra, there is a prayer for adjournment. In the interest of justice urgent to so and so. It is made clear that on the next date of hearing, the matter shall not be adjourned in any circumstances. As interim order is operating in this case. Yes.
my lord, item 1, my lord, Union of India copy we have not received.
You give the copy 2018 matter. Now you are asking for a copy. 2018 matter. He's asking for a copy now.
My lord,
Give it. You sort it out. I can't. Yes.
My lord, item 93.
1 minute. Yes.
Item 6 to 20.
Item 7, your lordship, on behalf of Counsel Hon'Ble Mishra, pray for 2 weeks after, on behalf of personal.
Item 10 also, I'm seeking for an adjournment.
Which one? 10 also.
Lordship,
On
item
request.
13.
On request. Adjourn.
Item 6 also similar.
6 also.
Lordship, item 14.
Why, Mr. Chand, you are asking for adjournment?
Because my lord, this is that.
Then there must be nothing in this matter. Just simply.
There is. In view of that delivery case, because she became pregnant.
See, these matters are to filed once also. It is not listed. I am trying to list it. Not next week. It will go at the court.
Lordship, item 14. Praying for an as. 14.
14.
Lordship.
Yes, 14 also on request.
36.
Item 34, my.
36.
34.
34. Okay, on request.
My lord, item 32, your lordship. Praying for short adjournment.
Which one?
32.
32.
32. Praying for short adjournment.
29 also. Okay. Adjourn. 29, 32, 34. So adjourn.
My lord, 75. My lord, item 75.
1 minute.
My lord, item 40.
1 minute, Mr. Patro.
Item 40.
Your turn will come. Yes, sir. Sorry.
Item 42.
40?
4.
44. Yes.
My lord, item 37.
1 minute. 44 also. Requesting for. Yes.
Item 39 and 40.
39 also.
39 and 40.
39, 40.
Yes, sure. So praying for short adjournment.
Item 42, my.
Remember, all these matters will go to June. In between, there is no chance. Yes.
Item 42, my. I pay 2 weeks after.
So everything will go to June after vacation. No? All this.
Item 79, my lord.
I'll just come there. Yes.
50 to 61. 62 to 67.
My lord, 6.
My lord, item 62, my lord. My apologies, my lord. The noting is that notice to OP could not be issued due to late filing of postal requisites. My lord, it was filed late, my lord.
The notice of 62, notice to the opposite party could not be issued due to the late filing of postal requisites. The counsel for the petitioner is seeking one more opportunity to file requisites. Let him do so within a week.
Requisites filed, but it was filed late.
The requisites already filed to be utilized for service. Please the matter.
68 to 75.
My lord, 69.
Item 71.
69. Lordship may see. Endorsee. Lordship, return answer with an endorsement, endorsee left without instruction, hence returned to sender. Two sisters. Lordship may remember that Supreme Court judgment. I will serve extra copy to the state. Let the copy.
Service through IO.
I
Service through IO.
in course of the day,
Course of day, advance copy to be given. Service through IO. Leaves the matter after 2-3 weeks.
I date hajur kar dele subidha di bhauni. Se koju sabu nei. He is a police officer.
Now, what do you want?
Put a
Date,
date.
na? Date will be given. Yes.
Item 71, my lords. There is a noting, my lords. The requisites could not be filed, my lords. Actually, we have given one extra copy. We'll file requisites to OP number 2, my lords.
Is there an interim order?
My lords, there is an interim order.
You have taken interim order, you don't file the requisites.
My lords, we'll keep it next week, my lords. Within today, my lords.
Not next week. How much you will pay, you tell me to the bar.
I'm sorry, my lords. Instead of giving refiling requisites, we have given extra copy, my lords.
Okay, you pay 1,000 rupees. Okay. Pay. Notice was issued on such and such day देख लेना इसमें 71 ना खोल क्यों नहीं रहा भाई
71.
why it's not opening huh it's not opening the how it will do notice could not be issued due to want of requisites. Requisites. Mr. Mohanty submits that inadvertently requisite could not be filed. He would be filing the same within during the course of
2 days,
day.
ma'am. 2 days.
2 days, subject to petitioner paying a cost of rupees 500 to the High Court Bar Association. Okay.
Great.
Interim order to continue. Yes.
Great.
Now it is.
My lord, item
Yes.
75. It was to be listed on 12th March, but it could not be listed. Therefore, my lord, I am requesting for any date in first week of April.
So 75, it is listed today. What is the problem?
My lord, I cannot travel to Cuttack today, my lord. That's my personal difficulty.
Hey, what do you want?
My lord, matter will be listed on any day after next week.
After vacation?
No,
Hey,
after next week.
What do you want exactly? I have to.
My lord, this is a petition under 482. The lady is a senior citizen, 70 years old. She has nothing to do with this case. And she is the wife of the government servant. On the basis of that, she has been prosecuted.
So what do you want exactly? You want an adjournment?
Yes, my lord. Today it may be adjourned to any other date in the next week.
Okay, urgent. Huh? Mr. Marana. Okay, urgent. Okay.
My lord,
Give a
I
date.
need my date.
Like give a date because Mr. Marana is not well. He's not coming. We'll just check it up and give it. Okay.
Thank you.
Yes.
76 to 85.
Item 79. Madam,
Yes.
So I have to take instruction from my client because 2 persons are, one is 86, 88. Unless I get a instruction, they will not be there. So I am not there. Only 2.
2013 writ petition.
By that after 16, today it has come. So when I seen that 2 persons, only 1 week after, I will come up.
Okay, I'll just check it up.
86.
What is the age,
70.
age of the, there are many petitioners.
My many petition, I will kindly see, those who are looking after case, those who are contacting me, I have tried them to contact, but phone is not available.
Okay,
So,
counsel for the petitioner submits that this
17.
matter is now listed after 2016. First
16.
time after 2016. The writ petition is pending since 2013. He wants to ascertain the status of
Only
the
one.
petitioners. Petitioner leaves the matter after 2-3 weeks. Let him see, eh?
My lord, item 84, my lord. 84.
84.
The opposite has party has filed a objection, my lord. We want to file reply. Maybe next
Who is
week.
the opposite party?
I have informed, but
Okay.
this is a matter of civil.
Submit that opposite party has filed a response to the objection. Objection, you would be responding to the same, at least the matter. Yes.
My lord, interim to content.
Thank you.
Oblige.
86 to 94.
Worship, item 93, matter relating to release of seized goods. Kindly posted it today, my lord. मैंने already 21 February थिला reach कर नथला. इतना sir kindly आज ही टिके से matter.
Be positive.
Sir.
That's only. I can tell that's only. Be positive.
Item number 91, my lord.
91.
I am for the OP number 2. Affidavit has been filed on behalf of the OP number 2 in CRLMC 3266-2024. But affidavit though has been prepared, his father is seriously ailing in CRLMC 3653/24.
Ms. Mansingh is there.
Yes, my lord. I am for the petitioner. He is
Oh.
for the OP2.
You want an
Notice
adjournment?
are gone by registered post. After that, my lord,
Simply I'll adjourn. Simply adjourn.
because Mr. Maharana,
91. Okay.
only I one thing I pray, because date is fixed for today. Allow me to that, we find the time to change that.
I don't know. Vigilance counsel has to tell.
Maharana.
The last date, no interim order is
Not
passed.
change. Only after filing the.
I will filing affidavit, already affidavit.
Today the date is fixed.
My lord.
Are you opposing?
I am for OP number 2. OP number 2, my lord.
Are you opposing his prayer for
No,
moving
my
an
lord,
application?
I am not opposing. I am
Let him move an application for adjournment before trial court. Yes.
Obliged.
Item 90.
Copy. Oh,
By the time the copy will get, we will supply the copy. By that time, whatever has to happen, it will happen.
I will inform the council. By that, obliged.
Okay.
Item 94, my lord. The matter will be listed for mediation on 21st March.
21st March for the mediation process is still going on. 95. 94?
94.
94. Mediation process is still going on. Okay. Okay. Yes. Next.
95 to 97.
Okay.
98 to 103. 104 to 108.
No, 108, man. I pray, can it be taken on 5th April, man?
Sorry?
108.
What do you want?
Can it be taken on 5th April?
5th April is a Saturday. Okay. Okay.
Okay.
Get ready with the notes and all.
Yes, all right.
Yes.
109 to 113. 114 to 120.
May I please, your lordship? 115, your lordship.
Yes.
This will be hard, so I can start also now.
So what do you want?
This will be hard because your lordship has hard so many times. So it will be finally it has to be hard now.
This is listed means it will be hard. But the time is to, why don't you do one thing? Why don't you do it on the 5th of April? That is a Saturday and a working day. At least couple of appeal can be heard. Shall I fix it on 15th?
5th April.
So that at least on that day you get the time.
Please, your lordship, no issue.
5th. Let it be on 5th. Yes.
Top of the board should be hard at least, your lordship.
The 5th
should be here. We're expecting an arrival.
Mr. Das wants that you should be here on 5th.
That I wanted to have to be hard.
See, that day I think we may get some time, so that's the idea. Yes.
Please, your lordship.
Yes.
Please.
Item 2 simply adjourn.
Pardon the petition, my lord.
Item-
Pardon to mention, my lord.
Simply, I'm,
Lordship, may fix up
somebody is
next week.
mentioning 1 minute. He's
Lordship,
getting restless. Yes.
Yes,
Yes, madam.
Lordship, I have to mention two items. CRL MC 3673 of 24 and CRL REB 270 of 24, Lordship. Both the
Yes.
matter compromise petition already filed, Lordship, and in both the cases, parties are agreement to settle their dispute amicably, Lordship. Kindly be listed on 19 March.
19th March. Is there anybody there in the physically on your behalf who can give the memo?
Yes, Lordship, not here, but file, today file.
You have to give the memo. Huh? You give the memo, we'll see. Okay. Okay.
Lords, in item
just
two,
pay
Lords,
the-
item two, Lords.
I'll give a date.
Smile.
Don't worry, I'll give a date.
Item two, Lordship, my record, Mr. Roth has supplied me a copy of that objection.
Mr. Rath has filed the written note of submission, which is taken on record, leaves the matter. Yes.
Well, item 3, my lord, I am for the petitioners. On some occasions, both the matters have come before some level court. The my lord will be separated, segregated. In
Both
fact,
the
one has no connection with the another. Because the order type, go take case order, how it gets repeated.
Somebody, you might have said that leaves the matter.
No. Or the to Pakha Gestella. I go second matter, nail, first matter.
No, the last order, just see,
Yes, lordship.
along with the criminal matter 2493.
Yes, ସେଇଟା ମୁଁ କହିଲା ପରେ ଅର୍ଡରଟା ଅଲଗା ଅଲଗା ହେବା କଥା ହେଇନି କିନ୍ତୁ ଅର୍ଡରଟା ଠିକ ଅଛି ଲର୍ଡ ସେକେଣ୍ଡ ମ୍ୟାଟରଟା
Yes.
ସେକେଣ୍ଡ ମ୍ୟାଟରଟା against the CLMC 2493 item against the rejection of petition we filed this petition, my lord. And the petitioner is one.
The first matter is not related.
No, that is also that I'll press also.
Both the matters are related or not?
No, not
separate.
Not separate.
Okay. You are arguing the second matter now.
Yes, first.
Okay.
Yes.
First, what about the first matter?
No, that also I argue.
Huh?
That also I will argue.
Argue first.
Lordship.
What do you want? First matter.
First matter, my lord, they paid for the quashing the entire proceeding. And first, my lord, my first and foremost submission is that this is this is the arranging out of 160 complaint case. And this, my lord, the judgment of Supreme Court that previous Srivastava matter has not been proved.
You are talking about first matter.
First matter, yes.
That is not. This is the Tirtol PS case.
Yes, my lord. Yes. It is out and out. It is a civil transaction. The informant availed a loan from the bank. When it defaulted, the bank has proceeded and auctioned his gold. Thereafter, my lord, to score his revenge, he has filed this case. While he was pursuing also the case before the consumer forum, where he has made the bank as a party. All.
And who are you? You are the bank manager.
I am bank manager.
Okay. Let us see what are the allegations.
All the documents say that it is a different relationship between the bank and the customer. The bank has proceeded. Charge sheet ଅଛି.
Where is the charge sheet?
Charge sheet also see there is an agreement. IFL Finance Limited.
Where is that? You told me.
Charge sheet. I have the copy of the charge sheet.
You have to place it because you are challenging the cognizance order. Unless
yes.
Counsel for the petitioner seeks an adjournment to place and record the copy of charge sheet.
So already there.
If you do so, have you filed?
Yes, already.
Where is that then?
Copy.
I don't know.
Yes, file for. It's there already there. Okay, sorry. Yes. Let us come to the charge sheet.
Lordship.
What are the allegations? What is your name?
The Kishore Chandra Swine.
Yes. Let us see. Yes.
You see, there is first there is an agreement. The application form, the IFL Finance Limited. Here, my lord, the borrower's photo is there, for signature is there, my lord. He has entered an agreement with the bank. And when you default, my lordship enter, the IFL, the loan place form is there, application form. That runs into 4 to 5 pages, my lord. Thereafter, the auction notice, again from the bank, my lord. Get on a paper publication. All the, my lord, the intimations have been from the bank. The bank is, my lord, the very strict person, it can be sued.
Yes. Yes. Notice was issued to the complainant.
So the order ta clear hai.
Where is the complainant?
Complaint is not yet up.
You implead the complainant. See, this has to be quashed.
But thing is there, now the grievance on the.
See, I'll tell you what grievance is. The complainant says that he has availed loan by mortgage.
Yes.
He did not pay the amount. So therefore, being a branch manager, he sent it to the head office. Head office asked him to auction the gold. He has auctioned the gold by publication in newspaper and all.
When the complainant wants to repay the entire amount along with interest.
How it can be?
How the bank manager is responsible?
He has to pay the critical interest.
He is doing his job as a bank officer. How can you hold him responsible? Where is the interestment? Where is the interestment? Interestment to the bank, not to the individual. Where is the interestment? There is no interestment. You have mortgaged the property, gold, with the bank. If at all, it is interestment to the bank. He being the manager, he carried out the instruction of
centralized control analysis
and followed the procedure. It was advertised.
Capacity. The bank manager is repetitive capacity. It is against the.
Then no bank manager can work like this.
Consumer
but why have you not implemented the complainant? I don't know. These are minimum things you don't do.
Consumer case file करके company file.
Whatever, you have a good case for Quashing, but you have not implemented.
Yes, I apologize. I will implement my law.
Then you have to face that. What?
I'll
the petitioner seeks leave of this court to implead the informant in the present case as opposite party. Number 2, let him do so within a week. Issue notice to newly added opposite party. Number 2, written evidence services take on. Yes, second matter.
Stay for the procedure.
First of all, you don't file.
But
what is this unnecessary?
Reverse against the state. They say
right now. Now you move application. Let him move application for it. Then. See, I could have. See, 2 hearing you have wasted.
It has a 15 acre asset list alani. Settle issue notice is going to order tare.
Apano party korchoti ki?
No,
this was you don't do and you want everything. Yes, second matter.
Second seller said that against the 457% rejection, this malad the bank malad has come. Here malad the order is that already an order. The
457 is allowed.
No. Industry stays level is the rejection kortale.
But where is that order? Where is that order?
Lordship, that is annexure 1. Lordship, kindly say annexure 2. That is relevant.
Yes.
22 page 23. Already an objection, my lord. Of this honorable court. So 24-25. Annexure 3, my lord.
You have implemented opposite party here also the same thing.
Lordship. Here the bank has brought.
Informant court. Yes, next.
My lord, I
informant you implement.
I am the informant here.
You are the
yes. Here the bank is the informant. One of its branch, my lord, a robbery took place, and some gold ornaments were seized. Against for release of those ornaments, they were filed with application. That application, lordship, the order clearly says that this is the property belongs to this the petition company. 24 annexure 3.
The court and think that the university officer said that he was submit report and where the board completely in favor of the petition, not and also the required for investigation, not whether to work at the guidelines also. It is in that IO did not submit the report even after. IO has not submitted the report.
So page 20.
No, by page 20.
25.
Get a report.
Yes, ma'am.
Get report and decide.
But reports are dated.
On the ground that IO has not submitted the report, it was rejected. Finally, also the investigating officer submitted a report where it is gold ornament have been deposited in the safe custody by SBI. Strong room located in so situation. So the direction of the court and for the direction of the which court? It was
SDGM Katak.
which court? Where is that order?
So there's lots of.
It is now kept in the SBI strong room.
Yes.
And the direction of the court. Which court? Where is that order?
Lots of page 25.
Reading 20.
No, 24, 25. And it's 3.
Where is that order you show me?
Lots of that is the
pursuant to the order of a court.
Huh.
It is now kept in the SBI locker strong room.
Lots of.
Where is that order?
That's
High Court order, trial court order, which order?
Lots of that is then.
Which order?
Lots of that Annexure 1, my lord.
Annexure 1 only I am reading.
Page 18.
Annexure 1 only I am reading.
Annexure 1, my lord. Page 20, Lord's sake.
Yes.
Posted.
In between just read.
That order was challenged.
Finally, on 23/5/2022, investigation has filed a report. A report reflecting therein that the seized gold ornament in the above case have been deposited in the safe custody of SBI strong room located in main branch SBI Cuttack as per the direction of the court. Which is that order?
Well, that SDGM's order was that is earlier order there.
Which order is that?
But let's say kindly say, and
I want to see that order. If there is an order on the basis of which it is put in the strong room,
some development took place thereafter, my lord.
You don't understand what I am saying. If there is an order, I need to know. How can I upset that order unless I know that? Because pursuant to the order of a court, now it is put in the strong room.
Lordship.
Which is that order? It is only written direction of the court. Which court? Where is that order? I don't know. You bring that order. Yes, simply adjourn. Yes.
Sort of.
Next.
Item 4.
Lordship, on the petitioner. Lordship, on the previous occasion, we were to sought instructions regarding the amount of arrear. Lordship, we were unable to contact the petitioner. Lordship,
Area is 6,38,000 as per.
Lordship, we need some time to confirm this amount. We were unable to contact the petitioner. Lordship, may I allow a short adjournment?
Yes, ma'am.
Next week.
On request of counsel for the petitioner. Adjourn. Yes.
Lordship,
Next week, ma'am.
Next, short date.
Short.
Maintenance. Entry mode. Yes. Yes, short date. Yes.
Item 5.
Made pledge, my lord.
To fight before my lord, senior starts, my lords. This is that matter, lordship, already.
Mr. Maharana is appearing?
Yes.
He is not well.
I may be allowed to proceed against the rejection of the application for discharge. The case is posted for charge. My only prayer is that, and I'll file an application for adjournment. He knows that.
Let them file because Mr. Maharana is not there. Since Mr. Maharana is indisposed, the matter cannot be taken up today and sent to social justice. In the meantime, petitioner may move application before the trial court seeking an adjournment.
Item 8.
Yes.
Settlement agreement. And for the opposite party.
Settlement.
And
Yes.
for the opposite party, my prediction.
What are the offences?
Offense 2N.
493.
376. Adjournment.
What are the terms of settlement? What are the terms of settlement? They have. What are the terms of settlement?
Already separated. They will lead their respective life.
What do you say?
Yes.
What do you say? 376.
Both are major, both are friends.
Major, that's right.
Both are friends. 26 years.
Appeal there. Now I have to take.
You either you oppose or you don't oppose. You are the prosecutor. You tell me whether either in legal impediment act, then you submit. Because both of them are major.
Yes.
They want to settle in their life. They don't want to proceed.
Yes.
This is the case. Do you have 164 statement? The investigation is still going on. Investigation is going on. Where is the charge sheet? Yes.
Cognizance with it. Last page.
Where is the, is there any 164 statement recorded?
Yes, 164.
Where is that?
164 statement has been.
Where is that?
That statement I am not
not received any.
Get 161 statement. Pass over.
Yes.
Get the 164 statement. You have to assist.
No, my lord.
Either you say I'll authorize, I'll allow.
No, my lord. Yes, my lord. Today I have not received. Just now I received the.
See 376, 493, 506 is there. They have settled.
Just now
either you have to say there is a legal impediment or not.
In the petition, there is no question of settlement. Now today they have
filed the affidavit. I can read it immediately. One paragraph. How much time it takes? Seconds. I read it.
Yes.
Is there any legal impediment? You have to tell me. The charge sheet is here. You have filed the charge sheet for 376, 2 and 506.
Yes.
Just see the 164 statement. And I am passing it over.
Yes.
Get it.
Please give the copy.
See, these people are coming unnecessary. Young people are.
I have to collect it. Yes. Definitely.
See, the young people are unnecessary coming to the court. Just see.
They have served this copy.
164
not today.
The siege bit take.
See, it was notice was issued to you and.
Yes. But things that after the copy is not available to us. Today just I am receiving.
What do you say? I'll put it to next week.
There's presence in the court.
What to do? See, if there is no assistance, I can't do it. 376.
That's.
I have to write something. It's 164 statement. I have to see what 164.
Only thing I can say that what is the allegations? Allegations is that all these things I can say. Only thing. But so far settlement. Now I'm receiving the
Petitioner
Impleading next week. Yes. You please read it and come. Otherwise, see, I can't waste time like this.
The FIR,
not FIR. At least either you say that there is a legal impediment you can't do, then I'll deal with that. Or you say that yes,
both are
there is
measure, that is
you can do it.
That is we are measure.
Measure that. That's right.
Yes.
They are measure. Now she says that I don't want to proceed. Whether I can proceed because 376 unless I have to record your statement. You are opposing or then I'll write that the prosecutor is not opposed. Shall I write it?
Shall
I write that prosecutor is not opposed?
No.
And if opposed, then you tell me why are you opposing? Unless you assist, how can I proceed? You tell me. Next week. Yes.
My item 9, I am appearing virtually, my lords.
Yes.
Yes, my lords. But the facts of the case are such, my lords. My predecessor in interest in office awarded a work.
You, Mr. Pradhan, you please on record the charge sheet. Copy of the charge sheet. File it. Huh?
I'll file it.
You have yes. Yes. What are you? Yes, Mr. Mishra. What do you want?
Yes. This, my lords, my predecessor in interest in office awarded a contract for 3 months. After the contract was awarded to party A, my lords, I will just tell the facts first. It was awarded to party A. The work contract has a clause that the work has to be executed by the party to whom it is awarded. Now what happens is that the present bills to be cleared. When the first bill is placed, my predecessor in office passes that bill. Then, my lords, out of nowhere, another person B comes. And B says that I demanded 10,000 rupees from him to clear his bill. Now an inquiry was held before the disciplinary proceeding to see if the stage for clearing that bill had arisen, because that can be cleared when it is 70% work done. There is a finding that only 12% work was done. So therefore the stage had not arisen. That is number one. Number two, my lords, there are three statements. I will show the dichotomy in the three statements, which will demolish their own case. Now the overarching point, my lords, where I am bound, my lords, is three judgments of the Supreme Court. My lords, my colleague is in court, where your lordship knows, my lords, what these judgments say, that in disciplinary proceedings, the standard of proof, my lord knows, is preponderance of probability, is the lesser threshold. In a criminal trial, on the self-same facts, the only requirement has to be self-same facts. The standard of proof is beyond reasonable doubt. So in cases where the disciplinary proceedings on self-same facts has been exonerated, it is a must case for quashing. This is the purport of the judgments. I will just show that. I will just show that. I understand because, yes, I will, because the general trend is that they can go on parallelly, they are not related to each other, etc., etc. But I have found these three judgments.
Which judgment you are relying upon? Kejriwal?
My friend is in court. Yes. Kejriwal.
Kejriwal is in a different footing.
No.
Kejriwal is, Kejriwal, Mr. Mishra, Kejriwal is regarding the adjudication proceeding.
Yes, in FERA, I am aware, my lords.
Yes.
Under the FERA law.
There is a difference between departmental proceeding and adjudication proceeding.
I completely bow down, my lords, that jurisprudence has now been extended to disciplinary proceedings. Simpliciter disciplinary proceedings. Your
Where is that?
Absolutely right.
Show me. I have reserved for a couple of matters. Judgment
Maybe
reserve.
this will help. I will just place that. Allow me to place that.
Show me one judgments.
Show the Delhi High Court
Kejriwal
judgment.
apart. Well, leaving Kejriwal apart.
There are in fact two judgments preceding Kejriwal.
Subhash Sharma. Yes. Which paragraph, Subhash Sharma?
Subhash Sharma, my lords. No, before Subhash Sharma, lordship will see. Lordship has the Delhi High Court judgment, my lord. Justice Mahajan's judgment. Because I am placing it because it relies on everything.
Which judgment do you want to show me?
I want to show PS Radhya, then Lokesh Kumar.
Yes,
PS Raja.
No, my lords will have the Delhi High Court judgment. It deals with everything.
Where is that?
Quoted there. It is quoted there. My colleague will.
Where have you quoted it?
Delhi High Court is Subhash Sharma.
Yes. It is Subhash. The name of the Delhi High Court.
This is Subhash. Yes, Subhash Sharma. Yes.
Correct. Now,
which
lordship will come to para 21.
Yes. Para 2.
Para 20, my lords. 20.
Yes. 20, yes.
Yes, my lords. Para 20. This is PS Rajya, my lord. This is a Supreme Court judgment. Lordships have it?
Yes.
Yes. In PS Rajya, the appellant therein were exonerated of all charges in this departmental inquiry conducted by CVC. And the conclusion of exoneration was concurred by the UPSC, which led to the passing of the final orders.
In Rajya, there was a CBC inquiry.
Yes, vigilance. It was a disciplinary proceeding.
Yes.
Number one, disciplinary proceeding, PS Rajya. The High Court there refused to quash. The Supreme Court said, no, you ought to quash. That is number one, my lords. Then second, my lords, para 22, Lokesh Kumar Jain.
Yes.
Lokesh Kumar Jain, FIR was registered alleging financial irregularities and misappropriation of 4,39,000 in departmental proceeding with identical charges. The appellant was exonerated.
I've seen it. Couple of matters I have kept judgment reserve. I'll reserve this also. It goes along with that, whatever fate.
Yes. In that case, lordship will allow me to assist because
Rajya will not help you.
No,
Rajya will not help you. I have dealt Subhash Sharma also.
This very judgment, man.
Two options. Either I'll adjourn it, wait till my judgment comes, or I'll reserve it and along with that it flows.
My lord, may I suggest, my lord?
I'll adjourn it. I'll simply adjourn. Simply adjourn because I am going to pronounce the judgment. I believe in this week or the coming week, Monday or Tuesday. So I'll put it after 1 week. Simply.
May not be 1 week because 2 weeks, my lord, I'm not available. 2 weeks. Any date, my lord, because any date. Because, my lord, on facts, if your lordship believes on law, my lord, the lordship is taking a view, then
I am taking a view. I am taking a view already. Raja, I am dealing. Subhas Sharma, I am dealing everything. You read that judgment, then you argue. Okay.
Yeah, because these all are they all deal with departmental proceedings, my lord. All of them deal with departmental proceedings.
Yes. At 11. Simply give after 2 weeks.
Any fixed date, my lords.
Yeah, fixed date. Yes. Mr. Marana, take a fixed date. I will. Yes.
May I please, your lordship? Alert, I have prayed for quashing of the criminal proceeding against the petitioner in the vigilance case. The vigilance case is, my lord, of the year 2018, but till that charge sheet has not been submitted, my lord. My lord, the petitioner has been embroiled in this case along with other officials, my lord, on the allegation that the petitioner at that point of time was working as project director watershed cum deputy director soil conservation Sundargarh.
Yes.
For 5 numbers of projects, payments have been made, my lord, without proper verification.
Where is the charge sheet?
Charge sheet has not been submitted till date, my lord.
Yes, Mr. Das. 2018 FIR, no charge sheet. I just issue notice, verify. Issue notice. Mr. Letter Counsel for the petitioner submits that the FIR against the petitioner had been registered on 26/12/2018 for alleged offences pursuant under section 13(2), read with 13(1) C and D PCH and 468, 471, 477 capital A, 120, 420 and 34 IPC. However, the charge sheet has not yet been filed, even after lapse of
more than
about 6 years. Lapse of 6 years. Issue notice, Mr. Sankaram Das accept notice. Status report to be filed. Yes. Yes.
Rejection of my recall petition, which I filed on 7/12/2023. The impugned order is at Annexure 3, page 22, wherein I have prayed for recall of 3 prosecution witnesses.
Sorry to interrupt, may I pray for an interim order stay further proceeding?
Where is the further proceeding?
Because
further proceeding is pending before the IO. That I'll say.
Investigation.
What do you want? Further proceeding is pending before IO. Shall I state?
I am on bail. I'll date to date.
That's right, but where is the proceeding? Your entire grievance is there is no proceeding. Charge sheet has not been filed. What can I say?
I have also retired from this job.
Good that you retired. Wait.
Yes, sir. Reason of making a prayer for stay by petition filed.
No, I filed. I is there.
What are you asking in I?
What is the prayer then in the midst?
Just because a corresponding DGR case is there.
Just because you moved an application, you have to say something. That's the. But your grievance is charge sheet has not been filed. Otherwise, I am issuing notice. Let us see the status. Yes. 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 You are referring to Annexure 3.
Annexure 3, my recall petition was rejected on 3/1/2020.
Recall of
3 prosecution witnesses, PW
3, 5 and 6.
And 6, my lord.
Okay. Who are they?
My lord, out of 22 witnesses, till date 7 witnesses have been examined. My lord, after the impugned order, my lord, no prosecution witnesses have been examined.
Who are they?
PW 3, my lord, I have annexed that at Annexure 2 series, their deposition, page 15.
Who is he?
Lord.
3.
PW3 is the senior assistant officer of senior assistant in the office of BDA. He was working.
Why have you not cross-examined? But PW6 you have examined, cross-examined very extensively.
PW6, my lord.
Who are you, joined?
No, my lords. I am for the accused joint general.
You also, the counsel for
accused relief.
Refuse to cross-examine.
Not the.
You refuse to cross.
I pray one date, not
6. You just forget 6. Talk about 3 and 5. 3 and 5 nil opportunity given.
Yes.
there I can consider. 6 you just forget, you refuse.
My lord, on the ground of his health, my lord,
Whatever, you have
page
refused.
21.
6,
No,
yes.
one date, my lord. Wait.
Vigilance case?
Yes, my lord, vigilance case.
3 and 5.
Yes, Mr. Das.
3,
Just
5
see,
and 6.
see, come to annexure 2. If you see, come to annexure 2,
Page 15.
yes, 15. If you see PW 5, now before that, sorry, before that you come to page 15, yes, page 15. And he is PW 3, and cross-examination part you just see cross-examination by the accused JK Jana, nil. Okay, and next if you come to page 18, the same nil. Okay, then you come to page 21. He refused.
Sir, on the ground of
Insofar as refusal is concerned, I am not going to consider.
No.
But
No,
these
what I
two have,
say on the
right?
ground of his health, my lord, it is written, but refuses to cross-examine
You are
witness on the ground of his client.
you are succeeding 80%.
But questionnaire is there.
I'll find them.
Whatever.
What are the question you're expecting?
He is not cross-examined at all. What question? He may do whatever. I cannot see if we cross-examine already done partly, then the questions may be relevant. He is not done at all. Let him do 3 and 5. Right on. Petitioner is agreed by the order dated 3/1/2024, whereby his application under section 311 CRPC for recalling PW 3, 5, and 6 for cross-examination has been turned down. And then counsel for the petitioner submits that out of how many witnesses?
22.
Out of 22 witnesses, only
7
witnesses have been examined as yet. And the trial is at
Both are BDS staff.
how the trial court rejected the application despite the fact that no opportunity was granted to the petitioner to cross-examine these witnesses. The petitioner has also placed on record the examination in chief of PW 3, 5, and 6 on record as annexure 2 series. Perusal of the annexure 2 series reveals that insofar as PW 3 is concerned, he was examined on 25 August 2022, and PW 5 was examined on 6 October 2023, whereas PW 6 was examined on 9th November 2023. Insofar as PW 3 and 5 are concerned, the petitioner, no opportunity appears to have been granted to the petitioner for cross-examination. However, insofar as PW 6 is concerned, the petitioner's counsel himself has refused to cross-examine despite opportunity granted. In these circumstances, I am for the considered view that the petitioner, being an accused facing a serious charge, is entitled to lead his evidence and cross-examine and lead his evidence and entitled to cross-examine the vital witnesses of the prosecution, where opportunity has not at all been given to him. Therefore, the PW 3 and 5 is to be PW 3 and the petitioner is entitled to cross-examine PW 3 and 5. Accordingly, the present petition is partly allowed. The trial court is directed to fix a particular day for trial court is directed to recall PW 5 and 3 and 5 by fixing a particular date and and afford an opportunity to the petitioner to cross-examine these witnesses. It is made clear that the petitioner shall not seek adjournment on the date to be fixed by the trial court. Petitioner is an accused in Vigilance PS case number 20 for 2005. of 2005 for alleged commission of offences punishable under section 13(2), read with 13(1)(d).
Yeah,
And
allotment of shopping.
120B IPC.
Allotment of shopping, that's Subham complex.
Yeah, let him examine. ठीक है, इस part दिया, ठीक है. Okay.
13.
Yes.
May I please, Your Lordship?
Yes, sir.
Here the petitioner is challenging the order where his application for sending the signature for the handwriting expert was rejected, Your Lordship. This is a case under the NI Act, Your Lordship.
NI Act, okay.
And here the specific stand of the petitioner in his reply to the notice, Your Lordship, is at Annexure 4, Your Lordship.
Yes.
He has denied that the signature in the check is by him, and the
Where is that?
that is Annexure 4, page 18, Your Lordship. You kindly see that is the reply.
Read my lord, total my lord. Other also has stated BJP, BJD background.
But the signature is false.
And also I am submitting. He has also stated that has been theft, committed theft. And the last part of the order, last part of the reply notice, he has instructed, I will instruct my client to take legal action on lost criminal cases against in proper court of law.
Where are you reading?
That is his reply.
Wait, which page?
Last
Paragraph 3, Your Lordship. That it is
last part.
presumed that
It is presumed that
knowingly and deliberately you have put forth signature in my client's name in alleged check. So I call upon you and reply your notice.
See, there is a specific statute.
That is his
Oriental.
Your Lordship, kindly see the order, my lord. There is a order of the
Judgment of Oriental Bank.
Your Lordship,
directly covered.
My Your Lordship, kindly see. He has stated, my lord, page 16 of the order.
16.
Order, my lord, fourth paragraph of the order.
Yes. Yes.
I have perused the record. It was found that on dated 19/2/2024, the complainant was examined and produced the original documents which were remarked as
Marked as
exhibits, wide order dated so and so, and the complainant has been cross-examined and discharged fully. However, during such course of examination, the Law and Counsel for the advocate has nowhere raised any objection as to the original documents filed by the complainant. And also, it is evident from the deposition sheet that that documents were marked exhibit without any objection. When the document was filed, my lord, he has not raised any objection.
Council, Your Lord.
Then, my lord,
It is the act
Your
of the
Lordship.
council.
No, my lord. Then, my lord, then Your Lordship come to page 17, my lord.
Yes.
Page 17, my lord, paragraph 3rd of the order. Third, my lord.
Yes.
In the present, the Law and Counsel for the accused has admitted the signature of the alleged check, which is very clear from the evidence of the PW1. It is not a case of the accused person that he neither signed the check or parted the check under any threat or coercion. Moreover, the accused person has not filed any post document relating to his signature, pass check in the order to verify his signature with the disputed section on the alleged check.
Why have you, in
then my
you
lord,
had a good case when you replied.
Yes.
But in the when you came to witness box, you have
yes, my lord. Then, my lord,
and allowed the document to
in both
come
the
on
paragraphs, Your Lordship,
it
is the
seems from
advocate
you are filing a past signature of the other checks, and it is only to delay that apart. The accused has not filed any. He has specifically stated that he has not filed also any criminal. Everything is there. He has admitted. Now at this argument stage, now at the last stage, my lord, straight to tomorrow, my lord.
73.
Your Lordship, in both the paragraphs, the advocate has admitted, not objected the document, Your Lordship, but
where is the statement of complainant?
Complainant, that is admitted, Your Lordship, nowhere the complainant has raised, but in the reply.
You had a good case.
Yes.
When you gave the reply.
Yes.
No problem. On that basis, it could have been allowed. Oriental Bank of Commerce.
Yes.
That judgment would have helped you. Today, when you came to the witness box, the complainant came to the witness box, then at that time you allowed the document to get in.
But that the process.
Then what to do now?
Is not aware.
Also argument stage, the Kallikals.
Kalliki Ochi, but Your Lordship, if Your Lord, under section 73, your lordship, the court can also examine.
That 73 I'll give.
Yes, your lordship.
But
The
my lord,
court-
this
No, no, 73. See, he has to give and he has to compare and take it.
Your lord. See,
Final hearing, at the final hearing.
Yes, finally.
Your lordship kindly see. See, check that.
See, you just see the para which you have read.
Yes.
17, para which you read. In the present case.
Yes,
What are the findings? Moreover, the accused person has not filed any past document relating to his signature and the past text. So there he says that there is nothing to compare.
That is my.
Now I'll say that file it and compare it.
Now, your lordship kindly. See, go to check but how he check, I will take back. He has not filed any.
I'm not on that.
Your lordship.
How he say, I will get my. Your lordship kindly for unless there is my lord dealings, unless there is some debt to be paid to me. So I will hand it over. Now see go to tar signature it olga thoughts
Just see, I'm passing a balancing order. Just see.
That has not been.
Wait, listen to.
से कौची भी पछ हमरको नहीं थिला बोली कोठी के भी कहि ना स्टेशन डायरी गोटे करथांदा चोरी गोटे तो किसी डॉक्यूमेंट नहीं था
1 minute.
से भी किसी
He has taken a very specific plea, but he has diluted his case.
डायरेक्ट बट
When he came to
its
the-
main document that we object करने माने जोटा main background of the case.
Petitioner is
Check
against
return
by
memo also
the
shows
1
that
minute. Petitioner is against
signature
by
is
the
matched.
order dated 3/12/2024, whereby his application for application praying to send the subject instrument to the handwriting expert to verify the veracity of the same has been rejected. And counsel for the petitioner submits that throughout his case has been that the check has been the signature appearing in the subject check has been forced and it was stolen. Stolen. He has taken me to the reply given by him, reply dated 16/8/2023, given by the given by his counsel in response to the notice under section 138 bracket B of NI Act. NI Act. He has NI Act. Para one of the said reply. Relevance, relevance, which means agenda. Para one could be para one. Don't interrupt me. I'm giving this. Yes. He has on the basis of the said stand, he submits that it was inevitable on the part of the trial court to send the check to the handwriting expert. He has relied upon the judgment of the Honorable Supreme Court in Oriental Bank of Commerce. Oriental Bank of Commerce. The learned counsel for opposite party, however, strenuously oppose the prayer made by the petitioner on the ground that although the petitioner has taken a stand that the signature in the check, signature appearing in the check it has been false, but when the documents were brought on record that time, the original document, when the original document was brought on record as exhibit, there was no objection raised by the petitioner. In the when the complainant was examined as PW1, there was no question put to the complainant in that regard as well. He has pointed out para. I have perused the record. Para 1, 2, 3, 4 of 1, 2, 3, 4. 4 of the impugn order to substantiate his submission. Para 4. I have perused the case record. Para 4 at page 16. Para 4 is 16. I have carefully perused the documents placed on record and the judgment cited by both the parties before the at the bar and at the bar. The trial court, while rejecting the application of the petitioner, has has also observed as under page 17, third paragraph, 1, 2, 3. In the present case, let an advocate for the accused has admitted. See paragraph, paragraph. In the fact scenario of the present case, I am up for the considered view that the counsel for the opposite party submits that the trial of the case is at the fact end, and the evidence has already been closed. Matter is fixed for final judgment. At this stage, interference of this court will further prolong the conclusion of the trial. He further submits that under section 143(2) of NI Act, there is a statutory stipulation that the complaints of the present nature should be concluded as expeditiously as possible within a period of 6 months. 6 months. I have taken into consideration the fact scenario of paragraph 2. And I'm of the view that since the matter is at the final stage, referring the checks to the handwriting experts would further delay the proceedings. Moreover, the petitioner has already allowed the original document to be exhibited without there being any objection. Hence, in the fitness of the situation, it would be expedient that the petitioner shall file his specimen signature or any past document before the trial court. The trial court, while deciding the matter finally, compare the signature, specimen signature, and appearing in the specimen signature with the signature of the signature appearing in the check, in accordance with section 73 as for the evidence act, and decide the matter as expeditiously as possible. Since the complaint case is pending since
2023.
2023, complaint case is pending since 2023. The petitioner shall not seek any adjournment before the trial court. And he shall furnish the specimen signature and a document, past document appearing his original signature to for the trial court to compare the same with the signature appearing in the check on the date to be fixed by the trial court. Yes.
Tomorrow is the date.
During this case, now see the outer signature and that will create also problem.
Past document. I said past document. Specimen signature, past document. Yes.
Intestinal raise all this at the argument stage. You can
see, but he has a right to rebut it.
But rebut in everything. I have also cited another judgment in this. The learned trial court has also.
See, then I can use that Oriental and send it. Oriental is straightforward. If at any stage he is taking a plea that the signature is false, then it should be sent to handwriting expert, Supreme Court judgment. So in that way, he has diluted. Unnecessary. Why to waste time again? I'll have to read the evidence and all. Better that 73 they'll compare and pass an order. Yes.
Obliged.
15.
Lordship, tomorrow is the date. So may I pray?
I will not say anything. You do whatever. Yes. Yes.
My Lordship. Lordship, it's not filed this proceeding.
Yes, sir.
So, question of the FIR. Lordship, FIR has been lodged against him. Offense under section 490A and other allied offences.
What investigation is going on?
Till now, 3 years has been completed.
2021.
My lord. Till today, charge sheet has been not filed.
So you matrimonial dispute 498, charge sheet is not filed.
That particular also.
I'll just issue notice. Obtain status. Yes.
Public.
Yes.
16.
Is there any chance of settlement?
Nude for
In this case, no marriage has been happened.
Approach the Hon'Ble High Court and Hon'Ble High Court granted 430 anticipatory bail, my lords. Then, my lords.
that is my learned friend is set for quashment of the affair. There is two affair, your lordship. What a 504, 545 and 701. 545 is lodged under some 498, 294, 323, 506. 701 is 376 and three other alleged offences, lordship. My learned friends are now praying for
Same accused, same complaints.
Same prosecution, my lord.
Yes, your lordship.
Same police.
Either 498 or
307.
or wait till the Supreme Court decides the judgment, marital rape. Either of this, you can't be.
First affair, husband.
So what is this? What is this?
Allegation, your lordship.
No, what is the stage?
But now the affair has been registered 4/9/24. I have no instruction further charge is filed or not.
And what about these other ones?
Other one is that is in the month of June, your lordship. That is in month of
Both the FIRs should be investigated.
Right to that part I will obtain.
I'll just issue notice with this. Verified.
Yes, yes.
One of the FIR has to go. Second FIR has to go. 376 has to go. If 498.
If there is 498.
Yes. Issue notice.
17.
The petitioner is seeking quashing of the which FIR you are seeking?
701/2024 short for quashment. Hon'Ble PS case
number 701 of 2024 registered against him for alleged commission of offence under section 376(1) and 376(2) of IPC. He submits that the complainant has also lodged another FIR, being Hon'Ble PS case number 545 of 2024 for alleged commission of offence punishable under section 498A, 294, 323, 506 IPC. Both the FIR cannot subsist together. Issue notice, Mr. Mahanti accept notice to file status report.
Quashment of both the affairs.
Yes.
My learned friend is quashment both the affairs. But proceeding, wording is proceeding, but short for both the proceedings. Yes, sir.
Yes.
17.
May I please, lordship? I'm challenging the order dated, my lord, 23/10 of 2024, Annexure 8, my lord.
Annexure 8?
My lord. The
Yes.
261 CRPC, my lord. Added the offences, my lord.
Yes.
And the page number relevant, page number, my lord, 63.
Yes.
That a part of content of the petitioner that the accused Megan of the about the pregnancy of the victim SCBC Cuttack and showing the 24-year married on found the not sustained by the documentary oral evidence till date. I mentioned para 6, my lord. And the relevant document I have submitted, my lord, Annexure 3, my lord.
Yes.
Annexure 3, page number 31, my lord. 21, 2024. And my age is 14th. And the accused person was duplicate Aadhaar card, my lord, page 24, my lord, of the year 24, and relevant point Annexure 4, series, my lord, 36.
Tell me, Annexure 3, why have you filed it?
Are the offences, my lord, in the pregnant and the abortion in the SCB Medical College, and the fraud is duplicate Aadhaar card in print the computer of the accused person in victim name, and I submitted all document in relevant document, my lord, SCB Medical in some after 1 month, 2 months, and deposit the.
So what do you want now?
Are the offences, my lord, in the. Lordship, whether is maintainable, lordship, try to going to lordship, I will bring the my lord.
And the state is not coming. How all the offences charges have been taken?
Well, charge already frame, my lord.
Then
and whether the
Your Lordship, earlier petitioner approached this before this honorable court under section 227, Lordship, that is CLMP 96 of 2023, Lordship, that order is annexure 5, page 46, Your Lordship. This honorable court, the relevant page is 47, Your Lordship. Kindly glance for a moment.
Yes.
Paragraph 5, Your Lordship. Needless to mention that the trial has just commenced, but the evidence of the victim is to be recorded. Once the evidence of the victim and other witnesses are recorded, and the court in session of the matter would come to the conclusion either on its own motion or in the motion being mooted from the side of the prosecution for addition or alteration of charge. The same may be taken into consideration. In Your Lordship, that therefore the coordinate bench is not interpreted. Your Lordship dispose of the.
So
therefore, my learned friend is approached with learned court by filing a petition under section 260 to add the and to alter the charge. Is it maintainable, Your Lordship, in case of the Your Lordship?
On the face of this observation, you can't do it. Where is that application he has moved?
Page 6, this is annexure 6, page 48, Your Lordship. 216 petition, Lordship.
216. Petitioner is the victim.
And my lord, meantime in the CLMC number 3242 of 2024.
The problem is strategically you are committing
my lord.
unnecessary, coming to the court repeatedly.
The direction to the already 261 and 61 and document relevant document. I have relevant document file and a rejection not added.
Where is that?
On the page number 64, my lord. Rejected order.
64.
My lord. The Honorable Court CLMC number 3242 of 2024, my lord.
So that you moved application, but in the face of the observation of this court, how have you filed this application? Let the prosecution do that. Prosecution do that. There is no evidence now.
No, evidence already filed, my lord. Original document AC medical already filed, my lord. And the 261 of the CRPC, any maybe the court may be altered the added any charge of any time before the judgment of the pronouncement, my lord.
At whose instance?
Who? 261 CRPC, my lord. Any court 216, my lord. Any court may alter or added to any charge at any time before judgment in pronouncement. मते सर आगे नेले मोर 24 वर्ष करिक मो ना ममता शतपथी ताको ना दिलीप शतपथी आगे एसी मेडिकल कर देले मोर वाश करे देले यूट्रस काटी देले मु आगे गरीब लोक नयगढ़ रहउची मु किछि केस विषय जानि नि पछरे डॉक्यूमेंट पाइले आगे जबरदस्त आगे मो यूट्रस भी काटी देछि देंगे दिस पेज नंबर रिलेवेंट पार्ट
इशू नोटिस
my lord 36
just check it up
my lord kindly I am a humble prayer my lord page number 36 only see my lord
I am issuing notice, why do you worry?
My lord,
let us examine 200 scope of 260. Yes. But every time you should not come to the court to prejudice your client. You came, took an observation. That observation is staring at the face of record. You should have waited. You should have routed the application under 216 through the prosecutor. That also you have not done. You should have routed through the prosecutor. That you didn't do. Under 302, you are barred. All these things are against you.
And
so it's very difficult now. Anyway, I am issuing notice.
My lord, prosecution through.
Examine. Next.
Prosecution through deposit the document, my lord.
Next.
Page number 33.
Let him.
My lord.
Now 18.
My lord.
Same.
My lord. Same, my lord. Only for a video conference. VC to Noyagada court to Kotak, my lord. Only for VC the victim girl.
Why are you creating? I don't understand. It's completely ill-advised.
First they filed a petition.
And
all the witness
allowed to victim
And
her
page number,
examined.
page number 32,
In
my
this
lord.
process,
Thereafter, file an allowed-
in this process, the accused will be acquitted.
And the second FIR
The
lodged,
over enthusiasm of yours
my lord.
to come to the court every time, being a victim, will inure to the benefit of the accused.
My lord.
This is for 100%.
And page number nine, my lord.
I'll just issue notice.
My lord, page number 9. Second FIR is lodged in High Court compound.
I can
in
see
come
the-
to the accused brothers.
I can see the over enthusiasm on your part,
My lord.
which is inuring to the benefit of the
In
accused.
that scope, the coordinates bench allow the accused petitioner bail or bail number 120/2024.
I know.
Same due to conduct of the.
I know he is creating problems.
And
for
the,
himself.
my lord, 11 para is
Okay, next, next.
to appropriate order of the
Both the matter in notice. Yes.
19.
deep rule.
For the matter to be taken up along with CRLMC number 4553 of 2024 because it's a connected matter and the matter has been amicably settled.
Connected why?
Connected.
How it's
is of-
connected?
It's of another co-accused wherein joint compromise
Same
affidavit.
FIR.
Same affair.
Okay.
Joint compromise affidavit has also
Please
been.
this matter along with
CRLMC number 4553
Yes,
of 24.
yes. 20.
Item 20. We also granted bail as per the FIR, my lord. For the charge sheet, the higher offences were added and cognizance were taken, my lord.
You are on bail.
My lord.
Susila.
My lord, Susila.
Petitioner is assailing the order dated 17/10/2019. Where is that order?
My lord, at Annexure 4, my lord.
4, 17.
32, the 11 case.
33.
Whereby the court of SDJM, SDJM, Jajpur has taken cognizance of offences punishable under section 1881, 82, 33. Page 33. Okay. Then counsel for the petitioner submits that the charge sheet was filed. No, petitioner is already on bail in the present case. The charge sheet was filed. The charge sheet was filed for 307.
24/9/2019 filed.
That time, acha. In the FIR stage, you were on bail.
My lord.
During the investigation of the FIR, the petitioner was enlarged on anticipatory bail.
My lord.
Anticipatory.
My lord.
And they would give the date.
My lord. 5/9/19.
5/9 anticipatory bail by this court in
ABL bill number 11,342/19.
After investigation, charge sheet has been filed in the present case on 24/9/2019, aiding a graver offence of 307 IPC.
307,
325, 326.
307,
325 and 320.
325 IPC. The trial court has accordingly taken cognizance. The court below has already accordingly taken cognizance for all the offences. The petitioner has essayed the cognizance of. However, at the outset, learned counsel for the petitioner submits that he would not press this petition at this stage, rather reserve his right to agitate all the issue before the court below at the appropriate stage. He expressed apprehension that once he appears before the court, he may be taken into custody in view of the addition of the graver offences. Therefore, he submits that some indulgence may be granted to him. Needless to say that the petitioner is entitled to move application before the trial court for grant of bail. If such bail application is moved, the same shall be considered in the light of the judgment of the Supreme Court in Susila Devi. To this observation, petitioner disposal.
Okay.
Yes. Good order. Okay. Yes.
21.
My pleasure.
Purchase नहीं करी थी.
21. The husband, before your lordship is the petitioner, has filed this petition for quashing of the entire proceeding. After filing of a divorce petition, this FIR has been lodged by the informant wife. Informant has been made as OP number 2. And the divorce case is now pending in the
Judge of Learned, Hamil Court, Khurda.
And issue notice 498 and all.
490.
Issue notice, yes. Yes.
22.
22, my lord, compromise matter for next week, my lord, any day, both the parties appear.
Not next week. To go. Federal Council for the petition seeks an adjournment. Release the matter. You have not filed anything. You filed the documents also.
Yes, my lord, next week.
And he seeks leave of this court to place on record the additional document. Yes. Let him do so.
23.
Yes.
May I please, Your Lordship? But here the petitioner is filing this CRLMC.
Sorry?
Petitioner is filing this CRLMC to quash the entire proceeding as well as FIR on the basis of compromise. The compromise affidavit is running page number 16. By
What are the
annexed-
offenses?
My lord, offenses are 341, 294, 323, 355, 500, 506.
Yes. What are the allegations against?
Allegation first, kindly have a glance to page number 12, annexure number 2, my lord. First, we lodged a FIR, hide 136 by 2022 against the informant group. Thereafter, the informant group lodged another FIR, hide 137 of 2022, dated 26/8/2022, my lord.
Thereafter.
And on a very day, that is annexure number 3, my lord, that has been compromised. Both the parties agreed for.
What happened to the other case?
सेटा भी सर compromise ହେଇଛି ଦିଟା ଯାକ ସେମାନେ withdraw କରିଦେଲେ ଆଜ୍ଞା 27 ତାରିଖରେ ସମ୍ବଲପୁରରେ ଦିଟା ଯାକ withdraw ହେଇଯାଇଛି.
Okay. So that case is already closed. 379, which you filed. What happened to that case?
And not taken any instruction, but
if you have settled both the matters, two petitions should be filed.
Settled, we'll just filed an affidavit that we want to.
That's right, but
Yes.
what happened to that the other case which you have filed against them? Get that instruction. Get that instruction. If that is the case, then you file another petition. Tag with this.
Another
tag with-
affidavit.
so that both the cases can be disposed of.
Okay.
That is issue notice. Yes.
24.
Yeah, please.
23. The council for the petitioner relying upon submits that the petitioner had petitioner on 26/8/2022 lodged an FIR against the opposite party for offence under section 379 /34 IPC. As a counterblast, the opposite party has opposite party on 26/8/2022 registered the FIR Dhamma CS case number 137 of 2022 for alleged commission of offence under section 341, 294, 323, 355, 500, 506, 34, and it is section 31 DERS and 32 VA of SC/ST POA Act. But the matter is both the matters are at investigation stage. Parties have entered into a settlement. He has relied upon the affidavit at annexure 3 to the petition. Issue notice to opposite party. Have you impleaded opposite party? You have not impleaded them.
No, madam, I have not impleaded opposite party.
Why are you doing disservice to the? You say that it is settled. You will not make them party.
Sorry, ma'am.
कौन है? नहीं तब देखो council for the petitioner seek leave of this court to implead the informant in the cases opposite party number 2. Let it do so within a week. Issue notice to the newly pleaded opposite party. Yes.
24.
May I please, Your Lordship? Here the offences are under section 279, 294, 506 and 34 of IPC, my lord. And the FIR date is 3/9/2022. In the meantime, my lord, 31/12/2022, charge sheet has already been filed against.
Then?
My lord,
yes.
And the
Sir, I'm
What do you want?
I pray to quash the FIR.
Charge sheet file means it is quashed.
No, my lord.
It is a routine clerical job or what? You make out a case, why should it be quashed? FIR laws, charge sheet is filed, therefore you quash. What is this? Why it should be quashed? What are the grounds? No ground. No ground. Whether you settle whatever, you withdraw it. The petition is also not happily drafted. Happily drafted. And counsel for the petitioner seeks to withdraw the present petition, reserving right to file a better one. Yes.
25.
Dismiss it withdrawn. Yes. Not a single ground written. Charge sheet is filed, quash. Was. Yes.
25.
25. What does he want? What is he seeking? In pass over कर I think it's a complaint case. I'll just come.
Section 67, public 67A of the IT Act. The allegation made against the present petitioner is that he opened to ID.
Before my learned friend starts, my lord, there is no charge sheet has been annexed. Even though the order dated, cognizance order dated 6/9/2021, there it has been mentioned that charge sheet has been filed. Thereafter, cognizance has been taken.
That I am challenging the order of
charge sheet.
taking cognizance.
Why are you challenging? What are the grounds?
Challenging that, Your Lordship, the two photographs with some obscene languages, which was posted by the informant as alleged, by the accused as alleged by the informant, don't attract the offense 67/67A of IT Act so far as the judgment of Hon'Ble Appeals Court in a case of Apurva Aurora and another versus state of NCT of Delhi, that there is no question of any lascivious or prudent interest that, Your Lordship. But I am sorry that another copy is not. So, Your Lordship,
Which paragraph?
Your Lordship, may I see that I have
Which paragraph? Yes.
highlighted, Your Lordship. So far as section 67, may I read, Your Lordship?
Yes. No, read the judgment.
Lordship,
Judgment
judgment,
you have
Lordship.
cited.
I'm sorry that, Your Lordship, I have sent for my junior to bring another one which has been.
What are the allegations?
Your Lordship, the simple allegation that two posts were posted through what is the application which gives rise to the loss of dignity and prestige of the informant's sister and his family, whose marriage was likely to be held with one Dharmanand Kausalya. So because of this posted of two photographs indicating some obscene languages, so marriage was broken. And there is no such name indicated that the petitioner is involved. So the statement of witnesses also revealed that only it is because of their hearing from outside. So it might have happened.
or not specific, nothing. The allegation or obscene allegation with the photographs never indicate any lascivious or appeals to the prurial interest. So the allegation is completely.
What is seized?
Seized, your lordship, mobile phones which have been seized.
What are the materials? Show me. By seeing those materials only, you will come to know whether it is obscene or not.
Lordship, the State Council may call for all those. It may be available in CD.
Yes.
The Lordship may CD be called for.
No, see the statements.
Statements, Lord.
Statements take out the
Right,
gate.
right.
And this judgment will not help you.
Right, Lord.
The judgment will not help you.
The Lordship may kindly see page 22.
Yes.
The statement of Dharanand Kuslia.
No, come to page 16.
16.
Yes.
Here 15 also.
15 and 16.
15 and
15, Lord. ମୋ ନାଁ ମଧୁସୂଦନ ପଲିକିଆ ଅଟେ ମୁଁ ଆଜି 25/2/2020 ଦିନ ଆପଣଙ୍କ ଆଗରେ ଏଇ ବୟାନ ଦେଉଅଛି ଯେ ମୁଁ ବର୍ତ୍ତମାନ ଜଗଦଲପୁର ଘମଟଗୁଡା ପଞ୍ଚାୟତରେ ଜିଆରଏସ୍ ଭାବରେ କାମ କରୁଛି। ଆମେ 5 ଭାଇ ଭଉଣୀ ଯଥା ମୁଁ ମଧୁସୂଦନ ପଲିକିଆ, ବାସନ୍ତୀ ବିବାହିତା, ରଞ୍ଜିତା 4 ଚୁମକି 5 ନବୀନ। ଗତ ପ୍ରାୟ 1.5 ବର୍ଷ ହେବ ମୋର ଦ୍ୱିତୀୟ ଭଉଣୀ ରଞ୍ଜିତାର ବାହାଘର କନ୍ଧ ଗତିଗୁଡାର ଥରବାନନ୍ଦ ଶୁକୁଲିଆ ସାଙ୍ଗରେ ଠିକ ହୋଇଥିଲା, କିନ୍ତୁ ଗତ ତା 26/10/2019 ତାରିଖରୁ ମୋବାଇଲ ନମ୍ବର ସୁଆଂଶୁ ମୋର ମୋବାଇଲ ନମ୍ବର ସୁଆଂଶୁ ଥରାନନ୍ଦ ବିରୋଧରେ ବିଭିନ୍ନ ପ୍ରକାର ଖରାପ ମେସେଜ ଆସୁଛି। ଥରାନନ୍ଦର ବହୁତ ଝିଅ ମାନଙ୍କ
You have to see court and peruse the statement of the witnesses. I'm not inclined to entertain this petition at this stage of cognizance. However, liberty is granted to the petitioner to move specific application before the trial court seeking discharge. Taking specific application before the trial court in that regard. If such application is moved, then yes. Yes.
27.
Yes.
here the
NBW.
Here the FIR lodged by the principal Bhadrak College, Bhadrak, reading college mob.
Hey, what is he asking?
Quashing of the.
No. Impugn order NBW.
Yes.
11/1/2002. 11/1/2002. Where
Is
is
the
that?
accused number 9, 11/1/2002.
NBW, na?
Yes.
How many? With
9 accused person, petitioner number. The accused number 9 is the petitioner here.
Nine, huh?
Is the instigator to all the students who agitate against the college act. He was released on bail already on 2/9/2024.
Where is the NBW order?
No, cognizance has been.
No, see the prayer. You don't see the prayer. Impugn order of NBW dated 11/1/2002. Passed in GR so read the prayer. Pass it over. See the prayer and coordinate. Yes, next.
28.
May I please, your words? Here the petitioner pray for quashing of the affair.
Yes.
For commission of offence under section 294, 323, 386.
Yes. What are the allegations?
My lord, come to the.
The affair and the counter affair.
No, that's a separate affair. That's a separate affair. That,
yes, you answer to the court.
Yes.
Yes. What are the grounds?
My lord, I have taken ground that the day it is described that on 28th January 2024, the complainant came to know that some disturbance is going on in the above stated plot at Mahanadi Vihar. the complainant, in order to know about the veracity of the disturbance, he went to the site and found accused Dhruva Charan Bala, the present petitioner, along with 4 others were present there and damaging the boundary wall and gate of the said plot. On seeing this complainant, accused Dhruva Charan Bala and the other 4 persons started scolding the complainant in slang language such as so and so. And Dhruva Charan Bala caught hold of the collar and started assaulting the complainant. My lord, the petitioner is a general manager of State Bank of India. My lord, come to page number 38. 38.
Yes.
38. To whom it may concern. The certificate issued by the Assistant General Manager HR. It is to certify that Sri Dhruva Charan Bala.
Yes, I understood it. What do you want?
Quashing of the affair, my lord.
No, yes, merely because he's a manager in the SBI, it will.
No, he was not there on that occasion, on that day.
Then that is a case of alibi, then you have to prove it is the right stage.
It is improbable on the face of record.
Plea of alibi is a mixed question of fact.
My lord, it's a certificate issued by the State Bank.
That's right, it has to be proved, sir, in the evidence.
The FIR was lodged on 21st
You should
June.
have given it to the IO. I don't know in investigation what happened. You can't bring a slip and say that was it.
My lord,
It has to be, due process has to be followed.
My lord, State Bank may be made a party.
Why should I stay? Am I going to conduct a trial here? No, I can't do that.
My lord, he was on that.
You are
He was the bank observer.
Maybe. Why have you gone there? I don't know. Why have you gone there? What was the reason?
He was not there. He was on Assam, Guwahati, on that day.
That has to be proved.
On that day, he was at Guwahati. My lord, have a glance on that certificate only. Just have a glance.
I have read it. I have read it.
He was at Guwahati on that day.
Yes.
How can he come here and?
But this document has to be proved.
Yes, my lord. It's the original document, my lord. I have the original document.
And the FIR was lodged on 21st June 2024. The certificate
Why
is obtained on
actually-
8th July 2024.
So what? So what? He was not there on that day.
Petitioner is seeking quashing up for the Chauliagas PS case number 174 of 2024, corresponding to GR case number 722 of 2024. 2024 on the ground of 2024 allegations of the petitioner so and so. Relying upon a certificate dated 8/7/2024 issued by the Assistant General Manager HR of SBI, which is placed as Annexure 5 to the petition. The letter counsel for the petitioner submits that the petitioner on the date of petitioner was at Guwahati since 21/6/2023. 2023. Hence, the allegation made against the petitioner that he was present at the spot. What is the date?
On 28th January 2024.
28th January 2024 is a completely false narration. False narration. Narration. On this ground, the petitioner seeks indictment of the court for quashing of the entire proceeding. The petitioner's plea of alibi on the basis of the letter dated 8/7/2024 needs to be established under due process. Needs to be established during the trial alone. Hence,
my lord may say during investigation. My lord may say it is under investigation.
Investigation is going on.
Yes.
Charge sheet is not.
Not quite.
Okay. Plea of alibi and the plea of alibi and authenticity of the document placed as Annexure 5 to this petition needs to be gone into in accordance with law. Letter counsel for the petitioner submits that the investigation in the present case is still going on.
My lord may say
Hence, I am not, although I am not inclined to interfere in this matter at this stage, our liberty granted to the petitioner to apprise this fact to the investigating officer. The investigating officer may take into account the plea taken by the petitioner and deal with the same in accordance with the law at the time of filing of the final report, closure report, under section 173 CRPC. With this observation, petition is disposed of. Yes.
Another small prayer, Annex 3 and 3 to 5.
3 to 5.
3 to 5.
Yes. Yes.
Item 30.
Here the allegation is that, my lord,
I am for the petitioner, my lord. Here I have challenged the order of the cognizance under annexure 3.
3.
Page 18.
Yes.
The offense is under section 341, 294,
Yes, yes.
353, 270. Read with section 3 of the Epidemic Disease Adulteration Ordinance Act
Kumar Mahapatra.
and section 51B of the.
Let us see the allegation.
कोविड रेस्ट्रिक्शन वेळे ये obstruct करथला से जो गवर्नमेंट स्टाफ में. This is the allegation. Charge sheet also has been filed.
Charge sheet has been filed, my lord.
Page 16 and 17.
Yes, what are the grounds?
Ground, my lord, that particularly this disaster, Epidemic Disease Amendment Ordinance Act, that's clearly fixed the trial time, 1 year from the date of offense.
What about the other offenses?
Other offenses that will take their own time. But as far as this, the genesis and the root cause is section 3, it is says that the offense should be against a healthcare unit.
Yes.
And my lord, kindly have a glance to the section 3 of the.
I understand that goes. Then the other offenses, 341, the 294.
That will he has to face because.
Go and move application there. Why have you come for cognizance?
Because my lord, the time fixed by the ordinance that the trial has to be over within a year.
Okay, but you can tell that to the trial court. While framing charge, that charge will go on. The other charges will be framed against you. As simple as that.
Accordingly, section 5B of the Disaster Management Act also not applicable.
So therefore, you argue those things there before trial court. Why have you come here?
Once the time limit is over for the trial, my lord, the court ceased to be ceased, my lord. He cannot go ahead with the trial. The ordinance itself says that 1 year, and 1 year is over.
Petitioner is agreed by the order dated 8/9/2020, whereby the learned STJM Nagar has taken cognizance of offences punishable under section 341/294/353/269/270 IPC, read with section 3 of ED Adulteration Ordinance Act and section 51 bracket B of DM Act. Mr. Guru, Lieutenant Counsel for the petitioner, submits that insofar as the offence under section 3 of 3D Act, 3 ED Act, ED Adulteration Ordinance Act and 51B of DM Act is concerned, the same cognizance of the same would not have been taken after lapse of 1 year. After lapse of 1 year, as per the
no, my lord. Trial has to completed within 1 year.
Trial has to trial need to be trial is mandated under law to be concluded within 1 year. Whereas the trial court, ignoring the said aspect of the matter, has taken cognizance of the offence much beyond 1 year. Hence, he sits in residence of this court. The trial court has only prima facie taken a view that the offences are made out. At this stage, I am not inclined to entertain this petition. however, liberty granted to raise this point before the trial court by moving appropriate application. If such application is moved, the claim shall be considered on its merit. With this observation, petition is disposed of. Yes.
31.
31 is a similar matter were listed before last Friday, and that was, I mean, two cases were there, similar. Criminal miscase number 02/2025 and criminal miscase number 36/2025.
Yes.
These two matters were listed before the last week Friday, and the same was adjourned. The same matter today, this case.
My lord, for quashing of the entire criminal proceeding, my lord, the alleged offence are under section 20B to C of the NDPS, my lord. My lord, the alleged offence are under section 20B to C, my lord. My lord, the allegation is that the ganja was recovered from the house of the petitioner in his absence, my lord. And my lord, my ground is that, my lord, it is the admitted case of the prosecution is that neither the petitioner nor his family members were present in the house at the time of alleged raid and recovery, my lord. My lord,
yes,
the petitioner has been residing at Birdville, my lord.
Do you want me to examine everything at this stage? What have you filed? Nothing. Why don't you should file a declaratory suit. So file a declaratory suit seeking a declaration that you are a gentleman. That's all. Why are you doing all this thing? That's the best way of doing it. You seek a civil, file a civil suit with a prayer that declare me that I am a gentleman. The trial court will declare and finish. No case is registered, nothing. What is this petition? What are you trying to say? Do you realize this is an NDPS case?
There is no concession.
Don't invite wrong orders and it will prejudice you. Better you file a better petition, withdraw it, better file a better petition. Because if I write something, you may have a good case, it will prejudice him. What kind of petition you have filed? Simply you withdraw it and file a better one. Right. Then counsel for the petitioner seeks to withdraw this petition to file a better one with better particulars and relevant documents. With liberty, the same is disposed of. You file a better one, file all the documents, and what are the grounds? Yes.
33.
मैं प्लीज लड़से मैंने पिटिशन चैलेंज
yes
मैंने पिटिशन चैलेंज द cognizance order dated 2nd September 2024 passed by Lord Noyagada in one sys number 5/2024 which is annex 1 page number 14.
Yes.
My lord, allegation of the complainant in one sys number 5/24 मो झील फिना प्रधान रक्की प्रधान को मैरेज करथिला रक्की प्रधान ससुर धोबा प्रधान सासु जशोदा प्रधान और ददा ससुर गोपाल प्रधान ताकू बाड़ाई मारी देछंती पुलिस को इन्फॉर्म न करी संपर्कियों साहाय्य शपदाह कर देछंती जहाँ फल इटामाटी पीएस केस होईची अंडर सेक्शन 498 302 201/34 आईपीसी एंड 4DP एक्ट इन पीएस केस नंबर 146/2023 पिटिशनर माने शपदाह करछंती किंतु पुलिस एक्शन नेला नहीं जहाँ फल वन सिक्स केस दिस इज एलिगेशन इन वन सिक्स केस एनेक्स 2 पेज नंबर 15 to 19 my lord
yes
my lord as per allegation petitioners are co-villagers of the complainant and deceased husband they have only cremated the dead body as per allegation my lord after death of the deceased the complainant lodged the FIR against her husband parents in law uncle in law by the Itamati PS case number 147/2023 annex 4 my lord in the said FIR no any allegation against the petitioners police also submitted charge sheet against the husband parents in law and uncle in law under section 498A
it's a 302 case.
My lord 306 against
you have helped you allegation is you have helped the principal accused for, destruction of evidence and all.
My principal accused evidence continuing in ST case no 261 by 2023. In the said ST complaint also examined, and he has no evidence against these petitioners.
Yes.
No any allegation against the petitioners. And also, they have also released on bail by the Hon'Ble High Court, parents-in-law, uncle-in-law, and
yes. Yes.
well, say against the allegation, no any allegation against the petitioners in the either in charge sheet or in the FIR or in deposition in ST case 261 to
Come to page 3. Yes, sorry, annexure 3, page 20.
Yes, my lord.
You are party to the, you have cremated the body.
Only cremated the body as a co-villager.
No, you read the preliminary statement, initial statement.
Yes,
Accused Prasad Kumar Pradhan, you, Kishore
Yes,
Chandra
ma'am.
Naik, Dilip
Yes, ma'am.
Patnaik, KTF, so-and-so, cremated the dead body of my
Cremated.
daughter with the in-law member of my daughter. I lost the FIR. All these things are there. How can I quash like this?
But in the
Let
FIR,
him go on.
no
Let
allegation
him-
against the petitioners.
Petitioner.
In the FIR, no allegation. In the appearance stage, my lord. In the appearance stage, no allegation against the petitioners in the FIR.
Why are you saying no allegation there? I read it out. Page 20, just read it.
My lord,
This is the initial statement.
It's a 1/6 case. But in the FIR,
Yes.
no allegation. But in the
FIR
no
may not
allegation.
be. See, that is the reason the complainant was aggrieved. FIR was filed against the in-laws. Charge sheet is filed against them. Thereafter, the father of the deceased was, not satisfied with the investigation.
My lord,
He
no charge
moved
sheet
in protest petition. In the protest petition, the statements were recorded. In the statement, the allegations have come. What to do now?
It is not protest
How can I
petition.
quash it? Merely because in the FIR your name was not there.
My lord, after 7 months delayed, this 1/6 case has been filed. Against this
Yes.
petitioner.
Will you, shall I dismiss it, or you take the liberty and do whatever? I'll have to write, then it will be judicial.
Any liberty, my lord.
Petitioner seeks to withdraw this petition with the liberty to raise all the points at appropriate stage before the trial court. With this liberty, the petition is disposed of. Yes.
That's against the appearance bail also,
Yes.
my lord.
Next slide.
35.
Victim 35.
Yes.
There was a short point involved in this case. Whether the trial court has jurisdiction to impose cost while allowing 311 application. This is the short question. For the imposition of cost while allowing the application under section 311.
The fact that you are appearing, 6,000 is justified.
No, I am factoring to law.
Don't bring all these things. 6,000, pay and finish it up.
No.
He's,
No,
this
that is
petitioner
not
is
the
spending
issue.
more.
Paying
challenging-
6,000 is not issue. Whether
Mr. Pradhan, don't burden this court. Lot of issues are there.
No,
6,000, 2,000
you know
technical
that
issues. and-
CPC section 35 provides imposition of cost.
You're-
Whether CRPC provides that.
I am with you. I'm with you.
Exactly.
But
If
how,
there is- if
how
there
much
is no
this,
such provision.
how much this gentleman might have spent to save 6,000? Why academic discussion?
This is the act. No. Well, if that will not be stopped by this honorable court, it will go on. It will go on. That's why I have not filed any miscase also.
If I'll stop, then I have been imposing cost every time.
Yeah. But in a
I
482,
can't
no. Exercising power under section 482, High Court has jurisdiction, but there is no.
See,
dispute about that.
to discipline, sometime you need to impose cost, maybe higher side, whatever. But see, these are the academic issue. You are correct. The court doesn't have the power.
Yes.
I am
Expenses towards witnesses.
That is
there is a rule.
That is diet money.
2012 rule.
That is diet money.
Yes.
The diet money has to be paid.
Yes.
That's a different story.
What is the question of imposition of cost? That is the entire case. You let them file that reply.
I know. I see. If you examine, then is it necessary to examine this academic issue? That's what I'm wondering.
Yes, let them give reply. That's all.
Notice करके रख दिया।
Yes, yes. Let them give reply to the state. Let them file a short affidavit whether they
June
trial
address,
jurisdiction
June
at all or not.
Right. Mr. Pradhan, Learned Counsel for the petitioner, 34 na, item 34 thila? 35 thila?
Very expensive, you see. 312.
Petitioner challenges the order dated 18/12/2024 passed by the ad hoc additional sessions judge come fast track court Bhubaneswar in TR case number 434 of 4/2024, whereby while allowing the application under section 311 CRPC, the cost the trial court has imposed a cost of rupees 6,000. Mr. Pradhan, Learned Counsel for the petitioner submits that the procedural court has no power to impose cost while allowing an application under section 311 CRPC. Issue notice, don't accept notice. Please take up, yes.
36.
May I please, Your Lordship? My Lord, this is a commercial dispute actually, and in apprehension of monetary loss and
use the mic.
My Lord, this is actually a commercial
mic. Yes.
This is a commercial dispute.
কাম করছি না নি? কাম করছি। Yes.
This is in fact a commercial dispute arising out of a franchise agreement, and the FIR was filed on apprehension of monetary loss. In fact, the petitioners had filed anticipatory bail, and they were directed by this honorable court to appear in settlement proceedings in mediation. In mediation, they have settled an amount of and they have paid the amount mutually agreed between them. So, my lord, we are praying for quashing of the proceedings.
Have you impleaded the? Where is the complainant?
No, he has not.
You have not implemented. You have paid.
My lord, I have in annexure.
Yeah, but who? I will ask whom.
My lord, I have attached the mediation report as annexure 2.
But you have to implead him. He may come and say that I am not bound by that. You implead him.
My lord, I will read out the paragraph. I understand, my lord.
You understand, na?
Yes.
Do it now. Implead.
Grateful, my lord.
Implead. Learned Counsel for the petitioner seeks leave of this court to implead the informant in the present case as opposite party number 2. Let him do so within a week. Within 2 days. Within 2 days, issue notice to opposite party, newly impleaded opposite party, renewals also. Learned Counsel for the petitioner has drawn my attention to the mediation report. Where is that?
My lord, annexure 2 series.
2 series.
Yes, my lord.
Mediation report dated 28/5/2024 and submits that the matter has already been settled through mediation, and he has already made good the entire payment as per the obligation flowing from the mediation settlement. Lease the matter. Good week for take out the notice immediately so that after 1 week I'll quash it. Okay. Yes.
Sir. May I please, your lord? My lord, I am appearing through VC. My lord,
First implead, file the requisite, and after 1 week the matter will be taken up. Yes.
May I please, your lord? My lord, the present petitioners are the husband and in-laws of the OP number 2, and they are praying for the quashing of criminal proceeding bearing CT number 137 of 2019, pending in the court of JMFC, Narsinghpur. My lord, in the meantime,
issue notice written on source. Matrimonial dispute. Yes. Next.
My lord, on 6 September 2024, the petitioner surrendered before the Landed Court of JMFC Rajgampur, and he was released on bail, my lord. And on the next date, my lord, on 19th September 2024, as the advocate for the petitioner is suffering from cancer, your honor, he has not able to take step on behalf of the
petitioner was granted the bail by the order dated admitted bail by this court by the order dated 29/8/2024 in ABPL number 8872 of 2024. 2024. However, due to absence of the petitioner from the proceeding before the trial court, the learned JMFC Rajgangpur by the order dated 19/9/2024 has issued NBW against the petitioner. For yes, allowed. Yes.
41.
Your Lordship, copy is not sought. Copy is not sought.
You are appearing for whom, madam?
Informant, sir.
Informant. Give a copy. Give a copy. Learned so entered appearance for opposite party number 2 on advance notice and submits.
In this case diary is requirement.
Submits that she has not received the copy of the petition. The counsel for the petitioner undertakes to supply the copy of the same. Call for CD. This the matter. Yes. Yes.
43. Beg pardon, my lord. My lord, there is. My lord, in item 37, my lord, there was an IFO stay for the proceeding.
We'll see. 498. Yes. Next.
43.
Item 43. Item 43. I may permitted from BC Millets.
Yes.
My lords, quashing of proceeding on the ground of compromise, my lords. Matter relates to matrimonial dispute, my lords. Notice may go, my lords. I have implicated, my lords.
498. Yeah. Each
my lord.
Each
my lords.
Yes.
313 is also. My lord.
45.
Yes.
May I please, your lordship?
Yes.
My lord, item number 45, my lord.
Yes.
My lord, maybe 2 weeks after, my lord. My lord, 2 weeks after. My lord, net is proper not working here, my lord. Sorry, my lord.
Net is not working, but you are also not wearing the band.
My band acha.
Okay. Okay. Display it properly.
My lord, net actually net is not properly
But
working.
I can hear you. I can hear you perfectly. You can argue. No problem.
My lord, कटी जाउची मझरे मझरे हयरान है, my lord. बाहर अछि. Oblige. Oblige, my lord.
May I please, your lords. Here the petitioner is facing a trial. Out of 25 witnesses, almost 13 witnesses have been examined, arising out of a 300 rejection petition. 25, 13 already examined. Out of 13, I pray only 4 witnesses to be examined to put only some limited questions which are direct nexus to the case. Here the
PW 1, 2, 3 and 10.
I have given those deposition later on, of course. It was not there at the time of filing.
Questionnaire
is there 311 you see.
Who are they? Who are they? P1, PW1?
PW1 is the informant who happens to be the wife of the deceased. 10 is the son of the deceased. 2 and 3 are two claiming to be the eyewitness, remain there at the time of meeting.
Okay. Show me their statement. Show me their statement.
Yes, statement, evidence. I have given, but it is noting is I have not supplied.
It's not there.
Yeah, no questionnaire. No questionnaire, no deposition. Petition.
No, it's not there.
Not there.
Lord, this is the copy I have received. After such a long period, it has come. I don't.
Very big.
Petition file करते
Lord Counsel for the Mr. Mishra and Counsel for the petitioner submits that he has already filed the copy of deposition of the witnesses sought to be summoned, sought to be recalled, sought to be recalled. The same is not on record. Raise the director to locate the same and place it on record. Advance copy of
Copy to the state.
be supplied to.
I have supplied again. I am supplied.
Okay. Please the matter.
In course of the day, just now I am giving you a lot of
yes.
take note.
Yes. Next.
48.
Your Lord, may I say?
Thought it good to week for it.
47.
47.
47.
47.
47. Your victim is not made party.
Huh?
Your victim is not made as a party.
No, what is he
informant is
asking?
the institute.
What is he asking?
Charge is challenging 10 and 12 of POCSO, my lord. and protection officer Sundargarh made party, but the victim are the student. Missionary school, the father is the accused.
What is he asking for? Quashing?
My lord.
On the ground?
Ground of compromise. Coming charge on.
Password for
48.
Against the charge he has come on the ground of compromise.
Compromise.
But here, my lord, how it could be compromised? Because the informant is the protection officer. He used to take party to the victim as the student of that missionary school.
Simply adjourn 47. Nobody is there, he's not bothered.
Most
None
should be made party.
None appeal for
Necessary.
We should be good. Yes.
Obliged.
48.
48.
Regular criminal appeal after conviction. 3 years.
3 years. Okay. 3 years. Okay. Yes.
49.
It's a Belgium matter. There should be bail order 27/6/2013. And the NBW was issued on 3/2/2025.
Okay. 500.
January, this was posted for recording.
500. Yes.
50.
NBW was issued.
50.
My lordship, NBW was issued on 6/11/2021. Actually, it is an NDPS case and the petitioner was absconded.
Absconding?
Yes.
Petition is absconding and we have to issue.
6/11/2021.
15 April.
51.
My lord, this is not a Belgium case. The maintenance proceeding and NBW was issued against me. Thereafter, I appeared, but the London court below has not recalling that NBW. For that reason, I have before your lordships.
Already appeared.
I have already, my lord, kindly page.
Once you appeared, it's gone then.
But my lord, kindly peruse the order dated. It was page 24.
24.
Order dated 30/11/24.
30/11/24.
The case record is put up today on being advanced by the OPs.
30 page 20.
Page 24.
30/11. Case record is put up today on being advanced copy. Further, he was praying for recall of BW and this including. A bailable warrant is issued.
It was, my lord, that was
see before that you just see 21/11/2024. NBW issued
my lord,
party has not been
mistyped as BW, but it is NBW, my lord. NBW, my lord. The order dated, my lord, kindly peruse. It was NBW.
Whether it is executed or not executed.
No, executed.
Then why are you saying? You go and appear.
I have appeared, but that was adjourned for further orders.
Where have you said?
My lord, 30/11/24, 7/12/24, and 25. And advocate both the parties, advocate for both the parties, put up on further order.
Advocate, where have you appeared?
No, my lord, I am appearing through my advocate.
You are NBW is issued against then once advocate appears, then gone.
My lord,
you have to appear.
I will appear. My lord.
That's what I'm saying. Right. White order dated 21/11/2024. Initial NBW issued when?
9/1/2023, my lordship. 9/1/2023.
9/1/2023. 9/1/23. The learned JMFC, which place?
Barampur, Ganjam Barampur. SDJM, Ganjam Barampur.
No, JMFC.
No, my lordship, it is Annexure 3, my lordship.
See the order where JMFC is written. 9/11/23.
SDJM, Barampur.
But JMFC is written.
My lord, it was transferred from different courts.
But who has issued NBW? JMFC.
My lord.
Why are you confused?
No, my lord.
I'm referring to that order.
My.
Hello. On 9/11/2023, JMFC so-and-so had issued NBW against the petitioner. They said NBW has not yet been executed. However, Land Counsel for the petitioner submits that on 10/11/2024, he has entered appearance.
30/11.
He had entered appearance before the trial court through counsel and prayed before the trial court to recall the NBW order. in the absence of the accused appearing before the court, the trial court refused to recall the NBW order. At this stage, he seeks indulgence of this court. On instruction, he submits the appearance of course. Yes. Yes. Problem.
52.
NBW was issued on 31/10/2022 and bail was granted on 23/3/2021.
Private. Yes.
53.
22 na 1000. 22 yes.
NBW was issued on 28/10/2024 and bail was granted on 10/8/2023.
500. Yes.
54.
54, my lord. The order of NBW, that is 6/2/25.
Yes.
The
Bail.
petitioner is bailed out by police. Can you see page 8?
500. Yes. Next.
Page 8.
55.
NBW was issued on 3/10/2024 and bail was granted on 6/12/2016.
Okay. 500.
56.
My lord, in this case, the NBW has been issued on 31/1/2024, but he was arrested on 25/3/2025, but subsequently was released on bail. But date, the order sheet conjoint reading to Chanapuni court date bail but he has been released on bail.
Then it is infractious.
No, now NBW has been issued.
अच्छा, fresh NBW.
That is 31/1/2024.
NBW 31/1/2026. 500.
Obliged.
Yes.
57.
Lord,
yes.
Before I submit the background for filing this review, Lordship may see the scope of this review, being aware that error. This is a case where operation was successful, the patient died. The very finding given against me has been, your Lordship may see, just I will take your Lordship's indulgence for giving a fact, just the compass of the...
Because of the delay in the proceeding, in many cases this happens. Successful patient died.
But this is a civil case. This is a civil case.
Many a time this happens.
Yes. Your Lordship is right. We have seen many times. But your Lordship sees, the case is very simple. The plaintiff and defendant, I am for the plaintiff.
Yes.
Plaintiff and defendant are two brothers. Twin brothers. There are certain admitted facts. Your Lordship sees that strip.
Yes.
That strip is 100 decibels total. 100 decibels belongs to the defendant. There is no dispute about it.
The entire 100.
Entire 100.
Yes.
I purchased 50 decibels from out of it.
Green part.
Yes. There is the rub. My case is that I purchased from the upper part, that is towards the road.
There is no access to the...
I'll come to it. That is my problem. I
can see.
Yes. There is no access.
I can understand.
That is my problem. There is no access. But I purchased that.
Whether it is red or green?
That is upper part.
Red. You say it is red.
Red.
He says it is
green. Now, question was...
Show me the part 2.
Yes. I'll just, your Lordship, kindly bear with me. This is the fact. There is no dispute about it. Now, the question was that the sale did show it is the southern part, the lower part. But the boundary showed that it is the northern part. So the dispute in the second appeal was whether the boundaries will prevail or the sale deed description will prevail. I will just straight away take your Lordship to that finding.
Yes.
Where I have succeeded in that. Kindly see page 20, paragraph 13.
13.
Yes. The dispute really lies in a narrow compass when the plaintiff claims that he has purchased the northern side of the land measuring 50 decibels from out of plot number so and so. The defendant disputes the same, saying that he has sold the same extent of land, but from the southern side of the is the only dispute. Then the interesting situation emerges that when we accept the case of the plaintiff in toto, the land as would remain with the defendant being his unsold portion would have no access, and for that he has to remain under complete mercy of the plaintiff. What your Lordship pointed out. Correct.
That's the
plaintiff to approach his rest of the land for the public. Likewise,
I'll issue notice to brother. Why you need some access?
Lord, question is the difficulty which lied with what you fell from your lordship, the defendant will suffer. Now I am facing them. Yes, the court after decreeing my suit has given the the lower portion to me. That is the error. Perhaps, Lord, with due respect, perhaps it was a mistake, Lord. I don't know. But I
see the problem with you is see the sale document where you got the title.
Yes.
That describes the lower
portion. The law as has been set aside, I succeeded. The court comes to a finding that
what about easementary right or all?
I gave the road. I gave the road. But he says that it will be under his lock and key. I will be at his mercy. The sentence which I read out, that he will be at my mercy if I go top. The same thing will happen. Therefore, the court rightly said,
what is the cost of the land?
I've been directed to give. I am ready to pay.
No. How the remaining half %? Why don't you purchase fully?
I'm ready to purchase.
I'll issue notice and call.
As your lordship.
Best part, either you give it or you purchase.
I am prepared to purchase.
Because see, whoever will take the lower part, he will be in trouble.
No, therefore, court comes to an arrangement that you leave a road. I have no problem with that also. But I have a problem that if both the persons, then I'll be at his mercy. Your lordship is right. Your lordship is,
let us sort it out. Forget about whether review is maintained.
Very correct.
Just we'll sort it out. Two brothers, either you take or he takes. It is a problem. If he doesn't agree to sell that part, and you sell it or something of that sort.
I'll come back to your lordship.
I'll issue notice and take out notice, and after 1 week I'll take it up and send it to mediation. Let us find out.
As your lordship, mediation had gone, but they did not agree for many suggestions. Anyway, lordship may issue notice.
I'll issue notice. It has to be sorted out. Otherwise, see, you keep on fighting, nothing will happen. Neither you are benefited nor he is going to.
That is exactly the observation of the Honorable Single Judge. That's correct.
So I'll issue notice.
But the only thing that for breaking, they have issued the execution for the time being, it may be stayed. I filed a petition, separate petition.
Separate petition. Stay of execution.
Stay of.
Then I have to write the reasons.
To stay, because if you're not
in a review petition, whether it's maintainable or not, this is another question.
Maintainable. This is the thing. After the court comes to a regular finding that boundaries will prevail and I am entitled to the northern portion, can again be one side it is.
In any case, I am aiming at settling.
Yes,
that not to aggravate.
That's
issue notice. Mr. Arvin on the left and senior counsel taking me to para 13 of the impugned judgment submits that there is a dichotomy in the finding. Therefore, he seeks indulgence of this court in the review petition. Issue notice to opposite party also. And in the meantime, the proceeding before, where is that?
I have given a petition.
The execution proceeding?
Separate petition will not show.
Where is that execution? You have not
that is
particular.
Lord.
Stay of the operation of the impugned order.
Or your lordship may direct stay of execution, Lord, that is.
Execution you have not said what?
No, I have not. I have stated that stay of operation of the impugned judgment. Because the directions are to be followed. That IA I have given. No, but
it can't be executed also. The way the finding is there,
that
can't be executed
also. Not that I am deeply obliged with that. That way it has created more confusion.
Stay the operation of the impugned order. It's very difficult to execute also.
Very difficult. Lord. That is, both sides will suffer.
Yes. 40? Passed over.
Yes. Made party to the informant to be made party. Yes, made to party to that is one FOXO. FOXO matter informant is not challenging passing of
47. Let him 47 and counsel for the petitioner, Mr. Our counsel and counsel for the petitioner, seeking leave of the court to implead the informant.
Informant and victim.
Victim is also you have to do it. Don't write the names. Only informant and victim. That's all.
Sorry, may I give the execution number for your lordship?
I state the operation of the impugned order because that is your prayer. Why to get into?
That's
yes.
My lord, item 67. May I be permitted to withdraw?
This we are, the administrative side we are taking care of. Hmm. Down the line, it will be a problem.
This also amounts to obligation articles.
Then you have to resort to jurisdiction. I can't. I'm not assigned with that job. You better mention before I read court. I'll just see what can be done. Yes. Yes.
25.
Yes. What is this matter? Non-appeals for the petitioner even in the second call in the interest of justice adjourned to July. Yes.
27.
Yes.
In prayer portion, there's a prayer for to quash the NBW order of NBW.
Where is that NBW order? That
Page 19. Page 19.
19.
19.
19. Okay.
This is the order of cognizance. There is
Yes.
no order passed for NBW.
There is no order of NBW.
Yes.
Non-appeals for the petitioner even in the second call in the interest of justice.
58.
Review application. High by mistake.
Yes.
The order for reading.
300. Take minute. Review petition 300. 4 days.
That was 246 days.
And FAO?
No. FAO man, that order, they have challenged before the apex court remanded. Again on remand, this on merit passed the order.
What is the delay?
No, FAO, there's no delay.
There was no delay.
On merit, it was decided.
Yes. On merit, it is decided. Yes. What is the explanation?
The same explanation you are putting in other case. Exactly same.
I'll dismiss in the ground of delay. On the ground of delay, dismiss. No delay. No delay in the delay. No.
I've given my access. So.
Very good. Yes. Appearance. Yes.
59.
59 and 60, you will also the restoration petition that this case 2 read petition arising out of
delay. How much delay?
Delay by that it was your lordship that kindly see the order, my lord. The ordering portion, if your lordship kindly see 752, I have quoted. Also, I have annexed a certified copy later on, my lord. Your lordship for para 2.
Yes.
Para 2, none appears on behalf of the petitioner when the matter is called. Defects as pointed, because it was for fresh admission, defects as pointed out by stamp report be removed within 6 weeks from today, failing which writ petition shall stand dismissed without. On that day, I could not know that matter was listed. I missed the list. Thereafter, automatically, in register without reference to the bench, it has been dismissed.
Okay.
Therefore, when I filed the memo for listing,
Issue notice. Let us see. Issue notice. I can't dismiss in. Yes. Issue notice.
My lord,
On the ground of delay. On the application for delay. Yes. Both the matter.
61.
My lord, on behalf of Mr. Raghunath Dasmatra, my lord, petitioner has filed this CRLMA petition to restore his CRLMC application.
The delay?
Reason of, my lord, during corona period, the advocate for the petitioner suffered in cancer and subsequently he died while he was under treatment, my lord.
How much delay?
Delay due to non-appearance of advocate.
Delay in filing this petition.
Number of days.
Is this petition suffers from delay? No. Because there is no application, therefore I am asking.
No, my lord.
There is no delay.
2 months, my lord. After dismiss,
Application for delay.
Trump reporters.
It was about copy. Copy.
There is no delay. There is no delay. Whether for the reasons stated in the application, the same is allowed. The FAO, what is this? Don't file anything, that's the problem. Criminal MA number 256 up to 2023 is restored to its original file. Yes. Yes. 63.
Lord, these are offense under section 341, 342, 294, 363, 366, 376, 109, 34 will be reduced section 4 of the POCSO, my lord. Already the matter has been settled, my lord. Already the matter has been settled, and now the victim is on your husband, my lord. There is a 9 years female child who is also residing with the husband.
Have you read the recent judgment of this court?
My lord, I am on judgment of my lord 2000, my lord 24, my lord.
Read the judgment, recent judgment of this court, whether you are covered by that or not. Simply read the judgment.
My lord's judgment.
Last week I have given a judgment. Just see whether you are getting advantage of the judgment or not. Okay.
My lord.
Yes. 64.
My lord.
Small prayer, if it can be taken up next, subject to your lordship's. Lord, I'm a little badly placed today with there's a parted matter which is going on from to the lunch. And my learned friend also.
Mr. DP Nanda, Senior Counsel, seeking 1 week adjournment as he is preoccupied with the parted matter. Leave the matter after 1 week. Yes.
There's an interim arrangement that
yes,
may be.
Interim arrangement because 65.
I filed an application for intervention. And the
Your
thing
lordship.
is,
Your lordships, I'm appearing for the petitioner. Your lordship, the conducting counsel is in some personal difficulty. So I pray if your lordships could be inclined to take up this matter on the April 10th. Your lordship, for the petitioner.
but I am not opposing his adjournment. Intervention may be allowed because here they have obtained this stay. That your lordship will decide whether it is correct or not. But there is a stay order in which our dues, which we are entitled to get, have been held up because of this stay. If your lordship may only clarify that this is a
Who are
case.
you? Who are you?
My lord, we are the workmen. This is against the labor court order they have come up.
Your lordships,
No, this is a criminal case.
Yes, criminal case.
Payment of wages.
Payment of wages act, your lordship.
Achha.
So, my lord, they are questioning the authority of the court below that why they have.
I'll allow your application to respond.
Your lordship, let them serve a intervention application on me.
I'll allow that application.
Your lordship,
let him participate.
Your lordship, a copy be served on me so that my learned senior will be here, so that if any case he wants to argue something on that intervention, I'll be over.
On behalf of the counsel for the petitioner, adjournment is sought because of the personal difficulty. Lease the matter also. Mr. Bose appears for the intervention.
Yes.
And submits that because of the order of stay dated 24/8/2023, the intervention workmen are suffering suffering. Hence, they seek intervention in the matter. Copy of the same be supplied to the counsel for the petition.
Your Lordship, interim order. There is an interim order. Lordship, there is an interim order.
Interim order, yes.
66.
Yes.
How a malicious proceeding has been initiated against the government employee. I have annexed the entire document, my lord. The vigilance draft was late. They have requisition to the collector office to accompany two official witness. I am one of the official witnesses. The complaint, who is the engineer, draft has been led. Prosecution has been lost. Detection report has been created. That has been by the vigilance department. I am one of the signatory in that case. He has been apprehended, remanded to the custody. After release on bail, what he has done, my lord? He has initiated a proceeding by way of initiating complaint case. In complaint case, if your lordship will peruse the entirety of the complaint case, there is no allegation against me. Your lordship may can see. Even though 156.3, which power which has been utilized by the London court below, it is not in conscience of.
Where is the complaint?
I have annexed, my lord.
Where is that?
That is starting from relevant person is, my lord. Starting from page 18. 18 of my brief.
Yes.
There is allegation against the DSP. There is allegation against
you are Brajokishore Behera.
Accused number 4.
Yes.
The complaint is the law. Accused number 5 is a contractor having many so and so, so and so. The complaint being a sincere officer who is the work perfectly and told the accused number 5 to carry out so and so, so and so. There is allegation, counter allegation, and demanded money. He has narrated that I have not demanded. Even though the entirety of the prosecution case, there is no allegation. He has demanded 25,000. That has been trapped. That has been seized from the accused. That is the present complainant. Your lordship can see. I have annexed the detection report. Collector directed me to accompany with the vigilance department, vigilance DSP. That much.
Let us see the charge sheet. What is?
No. Till today, my lord, the investigation is going on.
At this stage, how can I interfere like this?
My lord, to that extent, my lord, your lordship knows that while utilizing the power under section 156, your lordship knows that the Apex Court 2 judgments at my lord Justice Deepak Misra and Panam. The magistrate has to apply his mind whether it is required. Then, your lordship, state of Bhajan Lal versus.
Oh, don't bring Bhajan Lal into it. Investigation is going on, you are Bhajan Lal.
What is the allegation against me, my lord? Because I am one of the government employee, my lord.
Let it be investigated. How do I trap case? Trap case today you
trap case complainant na more than more. More accompany witness vigilance your lordship.
Let us see what the investigation is going on. Let it
for that reason, my lord, can I pray before your lordship? I have to take instruction. What extent the investigation has been? Your lordship, page 23 of my brief, my lord.
You have filed the selected documents.
No, selected no. Jahan se mat decho to se complaint pizza. Motte collector dele direction dele to accompany with the vigilance staff. They have requested page 24.
Yes.
Brajokishore Behera, employee. Thereafter detection report, page 25. Against the complainant.
At this stage, I can't go into all this.
Can I pray before lordship? What extent that has been gone? Because this case is related to.
Now there is an order of 156.3. Investigation is going on.
2017 till today.
Let us see. What is this case?
My anxiety before lordship, if the charge sheet has been submitted, then I could have been for that reason, my lord, limited prayer before lordship. 1 week after, I will produce the entire document before lordship.
Produce what?
That is the what extent the investigation is going on, what material they have collected, I will produce.
Okay. Mr. Das, let me call for the spare copy. No, state copy. Give a copy. Next.
Oblige.
67.
May I please, your lordship? Lordship, may I be permitted to withdraw this petition?
Yes, 68.
68. It made a kindly pass over. One pass.
Pass over at this stage.
Mr. Mahapatra will argue another court instructor.
You are paying for?
One pass over.
I'm the opposite party. This is very interesting case.
This
is a modification, my lords, of your lordship.
Modification of what?
Your lordship's order, my lords. Your lordship
see the last order and the prayer. How this is maintainable.
6/2/2025.
Then second, in compliance with this honorable court, my lords, they have already filed the application before the lower court.
Which order you are seeking?
Yes, ma'am. That, my lord, they have quoted, my lords. Delivered paragraph 5, my lords. Your lordship, order is quoted.
Order dated
Yes.
27/11/24.
Yes.
Which part?
That's paragraph 9. Paragraph 8, my lords. I'm inclined to allow the application of the petition, setting aside the ex parte order, only the ground that the series of direction made by the law court below, without affording opportunity to petition. Further, so far as direction number 2 and 3, as mentioned above, are concerned, the same has to be maintained till section 12 of the PWDB Act is application decided afresh, without affording opportunity to the petitioner. Accordingly, the petition is partly allowed. Section 12 of the PWDB Act petition filed by the opposite party number 2.
So, what is wrong in it?
Yes, my lords. Now they have made a prayer, my lords, for modification this order, my lords.
Modification of this order?
Yes, ma'am.
Yes.
Your lordship may kindly come to the prayer.
Yes.
Yes. Page 10, my lords.
Page?
Page 10.
10 of
10 of their bill.
application. Yes. Which application is that? I don't.
IA 3363 of 20.
No, IA is 305.
3363.
IA is 305.
No, where is the IA? IA is not there. Okay, okay. 305.
305.
Yes.
It is therefore humbly prayed that this honorable court may graciously please to allow the interlocutory application and to modify the order dated 27/11/24 in waiving out for compliance with the direction number 2 and 3 imposed against the petitioner 1 in deposing such and such.
This compliance, see, these are maintenance order. I can't waive that.
Madam, one more thing, just a minute. Your lordship. One. In compliance to this order, my lords, already the report application. And they're taking a plea that matter is submitted before the honor only to track the issue. Last order. 18 January 20.
Case is restored to its original file, subject to compliance of 2 and 3. Yes. He is seeking 2 and 3 modification.
Yes. Now they have also filed an application there and they have invited from the objection minor.
Oh, that I will not modify it.
Your lordship kindly have a glance to the order dated or passed by your lordship on
yes.
27/11/2024.
Yes.
My lord, may kindly see page 6 of my petition.
Yes.
So the ordering portion I have quoted paragraph 9. My lord, it is open for the petitioner to move appropriate application before the Illinois trial court for variation of direction contained in ex parte order insofar as direction number 2 and 3 is concerned. Your lordship granted me liberty to move the application with regard to variation of 2 and 3. But here, because of the direction that I will have to comply with condition number 2 and 3, so my variation application is not being accepted.
No, where have you said that variation application?
That from paragraph 8, your lordship order.
Where I have said that you can ask for variation, and the council is not taken into consideration.
Paragraph 9 of the order dated 27/11/2024.
9.
Paragraph
Yes.
9. I have quoted in my petition.
It is open for the petitioner to move an application before the trial court for variation of direction ex parte order insofar as direction of shown to concern. If such application is moved, the same shall also be considered. But sir, he considered rejected. That's all.
No, it is now not being rejected. My application is not been accepted for consideration unless I comply that.
Where is that? Where is that? Not accepted.
No, that no order is passed.
You,
The order itself, I think you lots of jointly read paragraph 8 and 9, it will be clear.
I understand, I read it.
My lord. Here the question that
the compliance,
the case that she is not getting.
Whatever these are maintenance application, section 12 will be decided and the call will be taken by the court below. Why are you worried about?
No, 12 is not being decided. 12 expertise order was passed.
It is restored now. It is restored now.
Now restored, but these other provisions portions are concerned that has not been considered. That is restored because of your lordship's intervention. Here, your lordship, it is not a case that the 12 application was we have come against the 12 on merit itself.
Modification
With regard to the expertise, we had come.
Modification application moved by the petitioner for modification of the.
Your lordship may say that currently we will go continue to pay.
Order dated 27/11/2024 to the extent that the condition number 2 and 3 imposed by the trial court while dismissing allowing the section 12 petition of opposite party ex parte. Mr. Mahapatra and counsel for the petitioner submits that the order sought to be modified. This court had allowed him to move an application for variation of the condition number 2 and 3. However, the trial court is not entertaining the said application. The order dated 27/11/2024 is unambiguous and the language employed in this order is clear, and therefore there is no modification required in this said application. But it is expected that the trial court should follow the direction contained in para 8 and 9 of the order to the letter and spirit. With this observation, petition is disposed. Yes, next.
Targeted my lordship. Your lordship, paragraph 9 or your lordship said that
8 and 9
reflected in the order.
8 and 9.
That paragraph 6, that just above that line, the order, because of that ambiguity, this is there. One hand, we have been directed to our application will be considered subject to compliance of condition.
I know, I've seen it. I've seen it. Yes, next item. Yes.
70.
Now number 70, my lord. Notice issued to the opposite party number 2 in her permanent address.
Yes. Sorry.
So I pray before unclaimed return.
It is unclaimed.
I pray before your lordship to issue notice in her present address.
Where is that presented?
Present address is mentioned in annexure.
Furnish the present.
To
notice on opposite party.
I filed this memo.
Permanent address. Therefore, land counsel for the petitioner subject structure. The notice be served. Notice be issued to the opposite party. The fresh address to be furnished by him by tomorrow. You fresh address.
Yes, madam.
Requisite to file with it. Yes.
72.
Yes.
My lord, I am 73.
Yes, sir.
72.
Are you appearing in 72? Yes.
My lord, in the noting of the list, that is the notice has been returned.
And notice was never issued.
Notice was issued to the sole opposite party.
No. It's a fresh matter.
For dispensing is filing a
Fresh notice. Fresh matter.
Fresh matter.
Yes.
No notice has been issued. Yes, notice was issued. Notice was not issued. Sushant Naik case. Anil Kumar Naik. No, Sushant Naik. 73.
No. Yes. 72.
72.
Non-APS for the petitioner in the
certificate.
Yes. 73.
73.
The service connection plugin is showing that and meanwhile undelivered. Undelivered.
That is not known.
Undelivered. Fresh address activation furniture.
Not known. So return sender.
Address is not known.
My lord. So your lordship may direct for a port service. So issue by port.
No, you have to take steps. What are you seeking, by the way?
By the way,
FIR.
man, there is a proceeding before the family judge Bhubaneswar for maintenance. So the sole opposite party is the wife.
Notice.
He has been
Notice
noticed.
on opposite party number could not be served. And could not serve. Then the notice returned back from the sole opposite party on 28 to 2025 with a postal remark that the address is not known. So returned to the sender and counsel for the petitioner to furnish fresh address and steps to be taken to serve opposite party on the fresh address. Please the matter. Yes, next.
My lord, notice was issued in the address of a present address, in our present address. But his permanent address is at Daspala.
You give that address. Yes.
Man, it is in the cause list.
You file that address because you have not given that address. Yes. Next, 74.
74.
My lord, another player, I may be permitted to amend the cause title because of collector and BDO are the necessary parties of this.
Then the counsel for the petitioner also prays for amending the new parties by impleading the necessary and proper parties. Let him do so within a week. Yes.
74.
74. Service.
7 days absent, hence return to sender.
Service on opposite party number 2 could not be effected. The postal remark indicates that what is that remark?
7 days absent.
7 days absent, hence returned back to sender. Fresh steps to be taken by the petitioner for serving opposite party. Yes. 25.
76. 76.
May I please? The IS 751 of 2025 filed for modification, that is the case diary is necessary at the time of hearing, Lord. 20 Tarikh Lordship has fixed that the case diary is necessary.
No, which order you are seeking?
Last order, Lord. Last order, not the.
Yes.
And that is also called for by the trial court, Lord. After submitting the Lordship's order, we have submitted at before trial court. And said a steady call for by praying for only 2-3 days, Lord.
Hey, what exactly you want? Petition?
Lord, the Lordship.
You should surrender.
Yes, Lord. That is fixed Lordship 20 on the 20.
Yes.
A case diary ta prayer korthile only 2-3 days remain more for surrender, Lord. Lordship fixed on
20th March I have fixed.
Lord. Only tapare 23 ki 24 Lord. Case diary ta asino thyo boliki prayer, only prayer.
See, if it doesn't come, then only cause of action is not erosion. You have come to hear.
Okay, my lord. Then okay.
Let the cause of action erosion.
Then I am not pressed, my lord.
Not pressed.
Yeah. Obliged.
77.
The wife of the deceased appellant want to continue the appeal, therefore file this IA for substitution, your lordship.
There is a delay and condonation of the
not filed
application
separate.
perhaps has not been filed. They need to file delay, yes, condonation.
I will file, your lordship.
Then only can substitution come.
Let the file application.
Next to your lordship.
Next.
78.
78 IA number 1033 of 2022 was filed for substitution.
IA number?
IA number 1033 of 2022.
75, no?
28.
78.
Where is that? IA is not there.
1033 of 2022 at flag D. That is for substitution. Another IA is 1032 of 2022 at flag C for condonation of delay.
Sodananda Naik.
Sodananda Naik.
Item 78 minutes.
IA is not there. I is not there on the cause. Just that I is not there. Look at that I. List it after some. Yes. Next.
Item 80. For petition was filed. There is a will in our favor by the shareholder. An application under Order 1 Rule 10 was filed that has been rejected.
Yes.
That will was subject matter of probate proceeding. Probate proceeding having been dismissed and appeal has been filed which is pending. So the petition suit, this probate will have an impact. So I should have been impleaded. That has been rejected. That is how this writ petition has been filed. Pursuant to the notice they have appeared, however, the case is being pressed there. So now the difficulty is, my lord, I am not impleaded. Now the share will be decided. Probate proceeding is there. There will be conflict of decisions. So therefore, this matter has been, my lord, brought on mention.
My lord, I am on
Where is the impugned order here?
Impugned order is at page 20, your lordship. In fact, the order starts from page 21.
Yes. Come to page 22. Peruse the case record.
Peruse the case record. This is a suit for partition and permanent injunction. Third party petitioners are claiming their interest in the subject matter of the suit through registered will dated so and so in favor of the executed by Mohadar. It is admitted case of the third party that the will could not be probated in case was dismissed. For dismissal of the on contest of it at all cannot be said that the third party petitioner have interest in the suit land. They are necessary proper parties, hence the petition filed by the petitioner to implement the mediation. But the court stops short of the fact that there is an appeal. Appeal is a continuation. It's not a second appeal. It's a FAO pending for the reasonable court. If that appeal is allowed, it's a registered will, your lordship. And it will definitely clear an interest. This is a suit for partition, your lordship. So in that context, it is very relevant. And your lordships have been pleased to hold time and again that the partition has to await the probate proceeding.
Right.
And this is an appeal that I have indicated that FAO.
But how this matter has come to me, this court?
Because this is against the Order 1 Rule 10 application that has been rejected. I filed an application. Assignment up to 2023.
Is it our assignment?
Up to the CMP up to the year 2023.
Okay. Okay. Yes,
So,
who is appearing?
My lord, I am appearing on behalf of opposite party number 1. My lord, as per my instruction, one passover. I may humbly pray for a passover, my lord.
No, only difficulty is it will not reach from next day onwards. I humbly pray your lordship may fix a date, only protect with an interim stay, because now the parties are for your lordship will decide. Let it be taken up as item 1. I have no grievance. They are now proceeding with the suit. So if the suit culminates, that will lead to further complications.
Suit for partition.
Suppose hypothetically, your honor, this noble court will be pleased to allow my FAO, holding that yes, the will is to be probated. The decision of the land trial court is wrong. In that event, I will have a right over the property.
You are the third party holding the will.
It's the employment word third party may not be exactly, my lord, in my humble submission, correct in the sense, the will being there, I cannot be said to a third party, I have a right. It has been put to probate, it has been rejected. Now it is in the shape of an appeal.
Are you related with the plaintiff and all?
My lord, that part I'll just point out to your lordship. Yes, but they are the heirs of some of the co-sharer in whose favor it has been executed so far as that will is concerned.
Yes. How are you related?
My lord, the interveners are sons of Dr. Pavitra Singh. The suit land is essential property of Pankaj Bala Singh, who has got the suit land in the partition suit by so and so, that is 94 suit. After getting the suit land, she is possessing as full owner thereof. Pankaj Bala was his princess and she loved the petitioners along with her parents, along with the parents of Dr. Pavitra Singh and Ramesh Kulu very much. He executed one registered will bearing number so and so in favor of the petitioner. So this is a registered will also. I beg to give emphasis upon this is a registered will. So maybe while considering the appeal which is pending for this noble court in the shape of an FAO, but this noble court may interfere.
Where is that testamentary case which was rejected, dismissed?
That I have indicated in page 7 of the
Do you have that order? Do you have that order? What is the reasoning?
That FAO
against which the appeal is pending.
My lord, the FAO is with me with your lordship's kind permission. I can produce it, my lord.
The reasoning of the court seems to be, since your probate petition has already been dismissed.
But
So
this
then-
part of that the appeal is pending, that has not been, because the appeal is a continuation. Had it been a case of not appeal anything else, things would have been different, my lord. This is an appeal. The right of appeal is a statutory right.
Where is Mr. Mahapatra?
My lord, due to some personal difficulties, he asked for a password, my lord. That's
Yes, Mr. Mishra, it has to pass. With the junior counsel is there. It's very.
No, I will never take a chance. A junior counsel is there, so I should press for an order. It's a case of only I am saying whether lordship may protect and hear. That much I am praying. I will not say that it should
The
be
protection order also I have to hear it. Because see, this matter is pending since 2022.
That's not an issue, my lord.
To 2018.
Yes, my lord.
No order is passed so far.
I am not disputing that. My lord, what I beg to submit, it also came on 24/7/2023.
Yes.
Couldn't reach. The matter has not been able to take
When
up.
we are probate petition dismissed?
Probate petition was dismissed on I'll just point. 18/8/2014. Appeal was preferred on in 2014 itself.
Yes. What is the stage of the suit for partition?
My suit is now has progressed for hearing.
What is the stage? I need to know.
Now it's posted for argument.
So at this stage, see 2014 thing and
The only thing
2018,
that-
15 you filed the FAO.
Only thing is that if your lordship hypothetically allows the FAO, I am not sure whether this is your lordship's assignment, that FAO. Suppose your lordship allows it. I think it is your lordship's
No,
assignment.
I understand it. If it allows, then the partition should.
There is already decree in place.
Yes. So, but this situation was there since 2014. You have not pressed it. Today, you filed it the FAO 2015. 14 to FAO.
Notice has been
And
issued.
this matter is pending since 2018.
Some only things I cannot say. At times you struggle to list the matter. I'll not say.
So I'll give a sorted.
At times we struggle to list the matter.
Sorted this.
My date by then I think the suit will be over. Let it be as a passover item for
Mr.
tomorrow.
Mr. 2018.
Let it be.
I can't pass an interim order
I'm
since
only
2018. No order is passed.
No, I'm only praying. Your lordship may take up tomorrow. It is there in the list, weekly list, my lord.
It is weekly.
Yes.
Let it be there. Let it be there. Okay. Tomorrow.
The difficulty is this. Because my lord, I will only say the efflux of time will not make this infractious. I will only say your
But
lordship.
you see, 2018 onwards, you didn't press it.
My lord, I'll not say anything more. There are at least 5,000 CMPs before this noble court.
Okay.
I think if your lordship assignment continues for 4 months, I think everything will not get adjusted.
Tomorrow you come just
Because,
if he succeeds in the FAO, then it will be have a direct impact on the partition suit. It has to be, the partition suit has to be stayed till the FAO is decided.
And that is one more difficulty. If one honorable judge is given an assignment of 5 honorable judges, then very difficult for the honorable judge to finish it, man. Your lordship is having so many assignments, and up to 2023 CMP, I think it's miles to go.
All CMP has to be heard.
Now, capacity dived koni. Why? I'm not saying that it's difficult for anyone to finish.
Let us see tomorrow. Tomorrow. Yes. 80.
81.
Technically, what is short interruption?
I beg your lordship, I am on a virtual mode, my lord. My lord, my small interested dispute here, only my amended petition has been rejected. Your lordship can turn to page, my lord, 18. The proposed amendment, my lord. It is a suit for partition.
Yes, can we take it up some other day only? Only one adjournment. I have to communicate. Only date. Which is convenient to my learned, actually any date which is convenient to my.
I have listed it.
It's convenient to you and him, but the court.
Yes, yeah.
You have to take into consideration court's convenience also.
Yes, sir.
My lord.
Any day.
Yes.
Can it be taken up tomorrow, my lord?
Not tomorrow. Not tomorrow. Yes.
My lord, fix a date, my lord, so that we can be.
Yes.
Short interruption. Item 74. 130.
Wait. Let us go forward. Yes.
82.
I am for the opposite party, my lord.
82.
I am for the opposite party, my lord.
Who is for petitioner?
That is a suit for partition, my lord. May I submit?
Interim stay is going on.
My lord. Plaintiff has already examined and cross-examined, my lord. And the different two also examined and cross-examined by the present petitioner, my lord.
But
This suit is pending for the evidence of the petitioner, present petitioner.
see, interim order is going on since 12/10/2023.
But for that reason, the suit could not be completed. My lord, pass.
Yes. 83.
Lordship, fixing date.
It's a weekly list, let us see. Yes. 83. Yes. Hmm?
After sending of charge, it is not responsible to 5. That was rejected. After somebody 76, 2A and 642 is there. That is not said.
And there is a stay, then petitioner will never come. Non-APS for the petitioner. An interim stay for the interim order is operating in this matter since 2000 since 20th of 2022. In the interest of justice, evidence shown to it's made clear that no further adjournment shall be granted. Yes. 85.
Results. Parties have settled the matter. And therefore they have approached your lordships under 482 for quashing of the proceedings in the court below.
Yes.
This is a case where an FIR was lodged, wherein the petitioners have been charge sheeted on 498A, 304B, 306, 406 by 34 IPC, and 4 of the dowry prohibition.
Yes, Mr. Bishop. 304B.
Yes, ma'am. The informant has already appeared and filed an affidavit.
Yes.
My lord.
What do you say?
The 304B is there. They have filed the affidavit settling the dispute between.
That I know. Are you opposing?
No, no. Since the 304 is there, it cannot be.
Therefore, you are opposing?
Yes.
That's what I'm saying. Are you opposing then?
My submission is, my lords, that if my learned friend opposes, what will happen is those 10 or 12 witnesses will go, stand and say, I do not know anything. And the docket of that court will only be crowded with this.
It's bound to be acquitted. And on what basis you are opposing? Do you have any judgment or anything?
Not now.
Merely saying I oppose doesn't mean you are opposed. You have to tell me why.
This is the case of
that I know 304B.
Therefore, the affidavit filed by the informant stating that we have settled the matter there. This is not.
That's all right. Everybody knows that. That's the fact. But do you have any judgment or anything to oppose that in these kind of cases court should not interfere and quash it? Do you have any judgment?
Not right.
Facts everybody knows. He knows. I know. Everybody knows.
Not right now. I will submit the judgment.
If you are opposing seriously, you must oppose it. Come with the judgment. Say that this is the judgment where the Supreme Court or High Court, any High Court says that no, you can't quash. Something of that sort. Merely saying no, I am opposing.
No.
Will not.
I will submit on that.
Next week, come with some judge. Otherwise, I lay out. Because these are futile exercise. You know, if all the witnesses have said, because see, the victim has died.
Yeah.
And the only parents, on the basis of oral statement of the parents, this case stands.
Yes.
If the parents comes and give an affidavit, what else you have? Nothing. Do you have scientific evidence that she has consumed? Do you have any scientific evidence? Anything? It is only oral evidence of the mother-in-law and brother, whoever it is.
Father-in-law.
Your prosecution only rest on these oral evidence.
Exactly.
If they withdraw, then what do you have? Nothing.
Let it come next week.
You say then apart from even if they enter into settlement, even minus those evidence, can you sustain the conviction? Can you ensure a conviction? Do you have any material?
Have you examined
Then? Because see 304B and all only oral evidence. Mother-in-law, father-in-law, all. No eyewitness. Do you have any scientific evidence? Anything? You said tell me. Next week.
Entry mode to country.
Entry mode to country. Yes.
86.
What passover at this stage?
One pass.
Yes.
87.
The petitioner is a practicing lawyer of this court, my lord. The petty offences are there, and your lordship also gone through the statements. Only the hearsay evidence, and the only offence is 341, 186, 431.
Yes.
That is the offence, mischief by injury to the public road. And it is the background of the case is that there is a water logging in the locality and they have stopped the vehicle. That is the allegation. And the statement which has been collected by ame shunibako pailu ki Surya Gupta sedi thilla. That is kind of evidence.
How many accused are there in this case?
8 accused persons are. Petitioner is the lawyer.
One of them.
A lawyer doesn't mean that you have immunity. If evidence is there, evidence is
no material man.
In 161 statement, ମୁଁ ଦେଖିବାକୁ ପାଇଲି ଯେ ସିଦ୍ଧେଶ୍ୱର ସାହିରେ ବିପର୍ଯ୍ୟସ୍ତ ପରିମଳ ବ୍ୟବସ୍ଥା ତଥା ଡ୍ରେନେଜ ବ୍ୟବସ୍ଥାକୁ ନେଇ ସିଏମସି କର୍ତ୍ତୃପକ୍ଷ ସିଦ୍ଧେଶ୍ୱର ସାହି ବାସିନ୍ଦାଙ୍କ ପ୍ରତି ଅବହେଳା ଯୋଗୁଁ ପ୍ରତିବଦ୍ଧତା ଜଣାଇ ସିଦ୍ଧେଶ୍ୱର ସାହିର ଦେଖିବାକୁ ପାଇଲି ମଧୁମିତା ରାୟ ଚୌଧୁରୀ ସଞ୍ଜୟ କୁମାର ଦାସ ନା ସୂର୍ଯ୍ୟ ଦାସ ଗୁପ୍ତା is present there.
Whose statement?
Rajendra Kumar Das.
Whose statement is that?
Rajendra Kumar Das.
The informant.
No, my lord.
Who is
the informant? Is the police, my lord. He has no acquaintance with the petitioner. He has only joined the office only 15 days back. And I have no such acquaintance with the, but how he got my name, that is strange, my lord. Because the two witnesses on that day, when the affair has registered, the Shailendra Sahu and Asutosh Das, those two persons, ମୁଁ ଜାଣିବାକୁ ପାଇଲି ଯେ ସିଦ୍ଧେଶ୍ୱର ସାହିର ବିପର୍ଯ୍ୟସ୍ତ ଅବସ୍ଥାରେ ଏଇ ଲୋକମାନେ ଥିଲେ ଜାଣିବାକୁ ପାଇଲି. There is no material. They have seen or something else.
Another person says, I have seen.
That's why your honor has gone through those statements and says that as there is no material, let's go through it. And
yes, what material?
And 431, what is the offense? Is there any mischief to the road? There is no mischief to the road. The offense is 431. What is the ingredients of 431? Whether it is attracted? If someone is standing in the road, that means the offense will be attracted.
Yes.
Whether there is any allegation by the public, the government, that they have been opposed to work by any work. Nothing. There is no material.
Come to page 27.
I have already given all the 161 statement, my lord. The offense is 431, mischief by injury to public road. Rather, water is logging due to the miswork by the CMC. पानी आगे रहिले नर्दमा सफा कले नहीं से पानी रोचे एरिया रे ताले भी लोक अप्रोच करेनि आ साधे जो जा लोक माने जो माने भल भल लोक अछथि वकील किए भल जे ब्रांडिंग लोक तांको ना दे देले पुलिस से पुलिस आसीबार 15 दिन भी हेनी एसआई जे देले एफआईआर. How he could know my name?
Yes, Mr.
I have no acquaintance with him.
One of the
except one statement was he stating.
Only stated that I have seen that he was.
Who is that?
That is the statement of Rajendra Kumar Das.
Read that. Rajendra Kumar
Das. Relevant portion ta paddu.
Yes.
The last portion.
Yes.
देखिବାକୁ पाइली जे.
Yes.
सिद्धेश्वर साहिर विपर्यस्त परिमल व्यवस्था तथा ड्रेनेज व्यवस्था को नहीं तथा सीएमसी कर्तृपक्ष सिद्धेश्वर साही बासिंदाଙ୍କ प्रति अवहेला जोगु प्रतिवाद जणाई सिद्धेश्वर साहिर मधुमिता राय चौधरी संजय कुमार दास सूर्य दास को ना द प्रेजेंट पिटिशन प्रबोध महांती सोनसो ओ अन्य माने रास्ता ऊपर टायर जाली सोनी मोटर सामने रे रास्ता रोको करते. This statement.
But the other witnesses have said that
they
came to know.
They have said they came to know. They came.
This is
How
the
I have
only,
statement. 5 statement सब came to know.
except this Rajan.
Except this
Another
statement.
is there.
किया है.
Dilip Singh.
से
Next is Dilip Singh also said, I have seen.
पूरा exact है
I have seen.
I have seen.
खाली exact xerox statement.
And what about the, there are 2 witnesses. How many witnesses have been examined by the police?
5 witnesses.
5. Out of 5, 2 have said taken your name.
Yes, ma'am.
How will you deal with this?
Witnesses are there.
How will you deal with this evidence?
Well, what is the material? And whether the offense is attracted?
That's a different story that we will examine. Because this is at the stage of cognizance only.
Yes,
Two witnesses have taken your name.
Only
very specifically.
They semana ya ama ideal ko bhi no.
All these things.
See, this was again. The how they have made those witnesses, they will not come up.
This is not the stage where I can
that I know, my lord. But the material, your lordship, can a lawyer who will face the
lawyer doesn't mean that.
Rasta roko kale 431. 186 offense hochi.
Then you file the specific application before trial court. I'll give direction to decide the application.
No, the offense is not attracting, my lord. Whether if offense your ingredients, whether there is a allegation that there is an injury to the road, whether there is an allegation that the public who was going to perform the duty, we have been restrained.
341, 186.
No one has been restrained.
431, 30.
Yes.
That is the offense. I am saying that.
The informant, the police SI.
Huh.
He has stated that.
So
inform
advocate
let's see. Let counsel for petitioner seek leave of this court to implead the informant as opposite party number 2. Let him do so by within 2 days. Issue notice to inform. Let the informant come. Yes. Yes.
88. 86 pass over remand warrant after charge sheet summons issue with the objection of Supreme Court. I will 86 pass over.
Pass over adjourn. Yes.
86.
Yes. 88.
Wrong for the push 83.
Oh, these are weekly list, na? Weekly list. It will remain tomorrow. Come tomorrow.
Tomorrow.
Allow me to implead here.
Yes. No, these are paperless court. You have to do it outside. Yes.
88.
Wait, please, your Lordship. Challenging the order passed by trial court, rejecting my application under section 227 under annexure 4, my lord, I have filed this criminal miss case, my lord. My lord, may kindly see the order.
You are appearing for whom?
My lord, I am for the complaint.
Informant,
sir.
Ready, Mr.
Yes.
So the last occasion, your lordship directed they will take instruction whether it will be amicably settled.
My client is ready, but my learned friend says,
in spite of this case being pending here, he is giving threatening calls and messages, which I have got, my lord. If your lordship permits, I can produce. So question of compromise will rise where? If there are cooling from both the sides. If the aggravation is there from the other side, in spite of having knocked the doors of justice of this honorable court, can there be, my lord, a cooling period?
Yes.
Well, here on merit.
Let's see the prosecutor is ready or not.
He has challenged the rejection of the discharged application.
Are you ready with materials?
Yes, I am
ready.
Yes.
Okay.
Well, let me see annexure 1. Annexure 1, the affair, well, page 12. Fact that they had relationship since 2021 and some sort of dissension crops up between them. Marriage proposal was also there. But from the side of the victim, my lord, there was some sort of problem for which it could not be materialized. It is alleged that I have also conceived through present petitioner. My lord, ultrasound has been done. This thing, that thing, my lord. But medical report is completely silent about her pregnancy, my lord.
a question crops up. There was some sort of relationship pertaining to assurance of marriage. My lord, admittedly, the victim girl is a major girl of 24 years and petitioner is of 30 years.
Yes.
I have also seen, my lord, the statement of the victim under 164, which also, my lord, if you will be construed, that will be seen that it's a girl has consent for the same. My lord, I will just draw two decisions of the apex court where this type of problem has
376 is not made out according to you.
My lord.
Yes.
My lord, I will draw the attention of my lord to 2000.
Read 164. Let us see the 164.
Same.
Yes.
Read it.
2000.
Yes.
ଆଜି ମୋ ନାଁ ସୌଦାମିନୀ ସାହୁ ଆଜି ସୋ ଇଚ୍ଛାରେ ରେଲିଭାଣ୍ଟ ପୋର୍ସନ ପଢୁଛି। ଗତ 11/5/2022 ତାରିଖରେ ସୋନପୁରକୁ ମୁଁ ବ୍ୟକ୍ତିଗତ ଭାବରେ ଯାଇଥିଲି। ଫେରିଲା ବେଳେ ତା ସହିତ ଦେଖା ହେବାରୁ ଚାଲ ଯିବା କହି ମତେ କସ୍ତୁରୀ ଲଜକୁ ନେଲା ଓ ସେଠାରେ ମୋ ସହିତ ଶାରୀରିକ ସମ୍ପର୍କ ରଖିଲା।
Your lordship may decide.
Yes.
Because my first ground is maintainability, that 482 application is not maintainable.
Yes.
And if they are challenging the order of discharge, my lord, if they have challenged the proceeding as a whole, the prayer doesn't say that proceeding as a whole is under
I'll
challenge.
tell you, if a application for discharge is rejected,
yes,
482 lies.
My lord, revision lies.
Charge is framed. No, charge is framed. See, it is an
now
against the charge, he has to file a
even 2.7 revision is
It's a
maintained.
final order where the appeal doesn't lie, revision lies.
Revision.
It is an interlocutory.
So revision lies, my lord. Then revision lies, not 482. 482 will not be maintained.
Whether it is interlocutory or final order.
My lord, it's a final order. This is the discharge petition is now there.
Final order is a culmination of this order would be the framing of charge. That would be a final order.
My lord, this will be the final order, subject to correction by your lordship.
This would can't be.
Because revision will be maintainable, not 482. And secondly, my lord,
Going to the academic thing, you come and let us come.
no, my lord, first your lordship may decide whether the revision is maintainable
Let
or
us see the
482.
impure order. Let us see
Yes,
the impure.
your lordship may kindly see the impugned order.
Yes.
32.
Page 32.
Yes.
My lord may kindly see the page 33. In the case at hand, I have already heard learned counsel for both the sides peruse the petition under 2.7. I have shown the 2.7 petition. Objection submitted by learned APP. I have perused the FIR charge sheet 161 and 164 statement, other connected papers. From all the relevant records, a strong prima facie case as alleged in the FIR is forthcoming against the accused. At this stage, there is no scope for this court to see other materials except the materials collected by the police during investigation from the
Which
documents.
material he has relied upon?
My lord, he has discussed everything. He has discussed from page 32, he has discussed everything. He has relied upon a judgment, my lord.
Judgments are not documents.
Yes. And he has dealt with the judgment. While disposing of 2.7, it is to bear in mind whether there is strong prima facie case made out against the accused from the documents submitted by the police. In other words, where there is sufficient material in the documents submitted by the police to draw presumption that none but the accused has committed the alleged crime, then he decides. But at this stage, there is no scope for this court to see other material.
Where is the material? Has he relied upon any other material?
We may discuss the materials in 2.7 discharging petition. No. What was the material placed before the court below? Your lordship has seen the discharge petition. It's a 2-paragraph. Let me, at the repetition, let me place that petition again. Your lordship may kindly see the petition. A person who comes to the court will first place that on these grounds, I will not be charge sheeted or a charge will not be framed against me. Just 2-line petition, discharge petition rejected.
You know, that court what they write in handwriting.
In such a discharge petition, of course, I have a very, very limited practice in criminal side. But I have seen such a discharge petition. My senior is master in that law. But with my very limited knowledge of understanding, is this a petition to be decided?
Shall I satisfied and send him back?
Your Lordship may let him reconsider. Let him, but this, first of all, your Lordship will decide whether revision is maintainable or 482 is maintainable.
Yes, Mr.
For the first time, I'm hearing this type of submission, whatever it may be, my lord. In a criminal case, as far as my knowledge goes, one line petition is sufficient because here we don't have to abhor each and every paragraph,
Yes.
each and everything as drafted in his plain or my lord, the application for order 1 or rule 10, whatever does matter. But here, an application has been filed drawing the attention of the court.
Do you have any judgment to show that it is an interlocutory order?
It's not an interlocutory order.
It's a final order.
My lord, application rejecting the application under 227, this case, criminal this case is maintainable. That is there in Madhulima's case, very first decision on the point, 78 Supreme Court till date. Number of times this type of objections has been raised in different courts and answer has been given. If my lord friend so wants, it will be taken up tomorrow or day after, I will answer it till date.
We should to continue on the question of maintainability.
Correct.
I am prima facie of the view that 482 is maintainable. But you just
He must have argued some cases on that.
No. I have already told that I have a very limited knowledge of understanding in this branch. To learn from my senior, I am not to teach him.
Maybe you can go and get some judgment against him.
He will, obviously he will provide me. I am sure that my senior has that pragmatic approach.
Yes.
89.
Item 89, Millers, although order criminal proceeding is under challenge, Millers, so petitioner wants to surrender, Millers, so he may be direct to surrender, Millers, first or second or Millers.
Well, petitioner is seeking quashing of order dated 24/1/2023, passed by Lieutenant S.T. Jain Bhadrak in GR case number 2664 of 2022, whereby cognizance of offences punishable under section so and so has been taken. At the outset, Land Counsel for the petitioner submits that he would not press this petition, rather reserve his right to execute all the points at the appropriate stage before the trial court. At the same time, he submits that some time is granted to the petitioner to appear before the court below and avail remedy, resort to the remedy available to him under law. Regarding it to the statement made in the bar, the petitioner is allowed to surrender surrender of which appear before the court below on 20th today. At least, and resort to the remedy available to him under law. Yes.
Millers, first or second or Millers.
Yes, if it is open for the petitioner to move application for grant of bail, if such bail application rules, same shall be considered by the courts below, through courts below on the same day. Yes.
Obliged.
90.
90, may I please, my lords. My lords, here the cognizance order under Annexure 3 is under challenge, my lord. My lord, that is running page number 24. My lord, on the ground, this is arising out of a 138 type proceeding, my lords.
Yes, you are appearing?
I am for
What
the
is check amount?
My lord, check amount is 10 lakhs. There are two matters, my lord. 25.
Is there any chance of settlement?
My lord,
Your lordship has already given that offer. I have also asked.
My lord, I have obtained instruction.
She has already made part payment before the court below and undertaken that I will clear up the dues.
Yes.
My lord, I am ready and willing to settle.
Right.
I am ready. She is saying it will 10,000 per month.
Let us see. He may change his mind. I am sending to mediation.
Well, mediation, let her then deposit some amount because she has already deposited 35,000 out of 20 lakhs.
My lord,
kindly see the intention.
My lords, just one point, if my lord may just have a glance. The sole issue in this case was, if your lordship come to running page number 21.
What do you want?
My lord, in this case, I am just a director, my lord, and the amount was transacted to the company, and the
company is not made party.
My lord, on technical ground, I am not right now because recent addition is there, my lord. But my lord, the managing director, Asit Kumar Satpathy, my lord may relegate this matter to
High Court Mediation Center photo and try to be reasonable.
My lord, my lord.
Lordship, my lordship,
5,000.
Lordship, direct that she should deposit some amount before this honorable court, not me. Before this honorable court, that's for the sake of her, that's the way she is dealing with me. Taken
10% of JKMO.
At least deposit before this honorable court or the court below.
10%
My lord,
amount to be deposited before the this court and subject to depositing, send it to mediation, awaiting mediation.
Interim order to continue.
Yes.
In both the matters.
Within a stipulated date, my lord.
Yes.
Interim order, my lord, continue.
Interim order to continue.
I'm grateful, my lord.
Yes.
The order dated 6th March 2024 under annexure 4, my lord, the subject matter challenge in this criminal miscase, my lord.
Yes.
The complainant was examined himself as PW1 and exhibited certain documents. Thereafter,
1 minute.
thereafter the case.
Nobody is for the Union of India.
Well, Income Tax Department, my lord, they have engaged counsel and they are contesting, my lord, this case.
Nobody is there. None appears for the opposite party, Union of India. In the interest of the don't appears, so Mr. Authority is for the petitioner. Release the matter. Yes.
93. And Lordship may fix your date.
Date. Fix a date.
Well,
May I
Yes.
please, my lords? My lords,
Yes.
on 22nd to 2024, the file lost under section 52A of the Orissa Excise Act and seized the goods IMFL by the leading party, third party from the vehicle, and vehicle seized and the possession of the driver. The allegation that illegal transportation of the liquor. In the meantime, the person was released on bail and vehicle released also. But the seized
When these liquors were seized?
Seized, my lord, on 22 to 2024.
21.
22 to 2024.
February 2024.
The seized article, duty paid articles and collected from the beverage corporation. And when the
What do you say? All are the liquor bottles, too many liquor bottles.
And
The petitioner has failed to prove that ownership of the.
Is the
He has granted power of attorney.
the power of attorney petition is before you the power of attorney holder, who is the license holder, my lord. I have annexed to
No,
one.
who is the license holder?
And Sikand Sharma, I have annexed to one series. The license holder.
License is issued in the name of who?
Sikand Sharma, my lord.
Shrikant Sharma.
My lord.
Where
Annexed
is-
to one series, my lord.
Yeah. Where is his name? Shrikant Sharma.
And the
Application moved by you.
I am the power of attorney holder looking after the Vigilance.
No. You bring Shrikant Sharma.
Sikand Sharma, my lord, because due to health condition, he is a power of execute power of
But
attorney.
somebody has to appear for him. Shrikant Sharma should come. He is the license holder. The authenticity of the power of attorney, everything has to be seen.
Annexed to two, my lord.
No, maybe, but the court is rejecting that. Court is rejecting that.
That articles, my lord, that seized article, my lord, is duty paid articles.
Let the Mr. Shrikant Sharma be file the petition.
Made party, my lord, then I will
You
be
may
party.
learn counsel for the petitioner seek leave of this court to implead Sri Shrikant Sharma, the license holder of the IMFL, FL and IMFL.
IMFL, my lord. Duty paid articles.
Let
Duty
him
paid.
do so. Within 2 days, issue notice to Shrikant Sharma. Yes.
95.
95.
Date may be fixed, my lord.
He'll give it.
95 last occasion.
Last
Also obtains instruction from the SP of that additional SP.
What was the order last time?
25th February 2025.
Have you got the instruction?
Yes, no instruction has yet been.
Pursuant to the order dated 20th February.
The order.
You have an interim order, you enjoy the interim order.
Because
2025, the state council has not obtained instruction, has not received instruction as yet, and seeks the opportunity to obtain instruction. Release the matter on
A short date will also.
interim order to continue.
A short date will also.
96.
What's happening? Yes. Yes.
Case of 490 arising out of 1/6 case 678 2014 matter.
Who is appearing?
498 506 34 4 DP Act.
Yes.
Notice was issued on
1 minute.
27th January 2025.
1 minute. 1 minute. Yes.
He was not impleaded as party, therefore
$97.
96.
Who is appearing for 96? Hard copy ଅଛି?
notice ଯାଇଥିଲା 27 ଜାନୁଆରୀ notice.
1 minute. There is some problem in server.
Today's also updated is replace server.
Hard copy ଅଛି କଣ? Let's see. Yes. Yes.
Notice was issued, but
What is their service?
yes, the informant Rasmita Paley.
Huh? Sorry? No, service complete.
Yeah, service notice was
नहीं Non-appeals for the petitioner, huh?
27/1/25. Mr. Marital, additional standing counsel for the opposite petitioner waives the notice.
Non-appeals for the petitioner in the interest of justice.
97.
May I please, your lordship?
Yes. Yes.
Your lordship, this is a vigilance matter for quashing of the criminal proceeding against the petitioner under section 13(1) and read with 13(1)(e) of PC Act, your lordship. Now, your lordship, in the last date, I've submitted one computation note of submission, your lordship. Your lordship, my submission would be the first, your lordship, first point, there is already a delay of 21 years, your lordship. If you see, your lordship, kindly come to date chart, that is page B.
Yes.
The date of FIR is, your lordship, 23/06/2024.
Yes.
The charge sheet has been filed in 2007. Date of taking cognizance is 7/12/2007. So now, your lordship, if you see, this is 2025 and there is already a delay of 21 years and the charge has not been framed, your lordship. Now, your lordship, coming to the second point, your lordship, last date of some in the last occasion, I have submitted one note of submission. For your lordship's clarity, let me explain this computation sheet, your lordship. Lordship, you have it? I have submitted, your lordship. There. One more copy.
Flag C. Yes, flag C, I got it. Yes.
Yes, your lordship.
Yes.
Your lordship, here the amount 12,32,270. It belongs to the wife, the established business in the name of the wife, where the wife was generating this amount, and
Wife is in a co-accused with you.
yes, your lordship, wife is the co-accused.
Yes.
Now, your lordship, if you come to page 83. Page,
Let us understand the chart which you are giving. What
yes,
is
your lordship.
5,58,500.
5,58,500. I'll come to that, your lordship. Let me first explain this 12 lakhs, 2 lakhs, and 8 lakhs, your lordship.
Yes.
Whereas 12 lakhs is concerned, your lordship, this amount the wife was generating from the established business of the petitioner, which is in the name of the wife, your lordship. Now, whereas 2,59,000 is concerned, your lordship, this is a sale amount of an immovable property. Now, 8 lakhs is the loan for the construction of a building, your lordship. As far as your lordship,
Sale consideration of which property? The property stands in your name. It stood in your name.
Yes, your lordship. There is a sale deed, your lordship. I can show you, your lordship.
Yes.
It's there in annexure.
Was that sale, that property was purchased during the check period?
Yes, your lordship. During the check period, that is 96 to 2005, your lordship. That has been there in the annexure 4 series, your lordship. I'll show you.
Total income according to you is 22.
22 lakhs. 22 lakhs 91. As far as your lordship, the 5,58,500 amount is concerned, this property, your lordship, kindly have a, this doesn't belong to the petitioner, your lordship, kindly have a glance to page number 123, your lordship.
But suppose you have purchased that land during the check period, the sale consideration will be counted towards the disproportionate asset. How do you say that it has to be deducted from the total amount?
Your lordship, this 5 lakhs, it shall be deducted because it doesn't belong to the petitioner, your lordship.
5,58,000, a third stranger, you say. That we'll see. I'm talking about 2,59,000.
2,50,000, yes, your lordship.
That is the sale consideration of a movable property.
Immovable property.
Stood in your name.
Yes, your lordship.
The property was purchased by you during the check period.
Yes, your lordship.
So the sale consideration will be counted towards the disproportionate asset.
But now I'll come to that, your lordship. I'll explain it, your lordship. So if we deduct 5 lakhs, which doesn't belong to the petitioner, which is there in page 123 of the main petition, your lordship, annexure 5 series, your lordship. If you come to that, then it shows that the property belongs to one person named Sailesh Pradhan, your lordship.
Who is he? How is he related?
He is nowhere related. You can say he's a distant relative of the wife of the petitioner, your lordship. Now, in the charge sheet, your lordship.
Your allegation is you have purchased the land in his name.
No, your lordship. Allegation is there that the property belongs to me, but the property doesn't belong to me. The property is completely someone else's property. I haven't taken the amount, your lordship.
Has he shown the sale consideration? What is his statement? Whether his statements recorded in 161 state?
Yes, your lordship. There is a state.
What does he say? He might have said that my brother-in-law has given me money to purchase this. That's the reason the prosecution has taken it to consideration.
Petition.
If the chart shows that the wife's property, then what happens? The wife is not a petitioner here.
Your lordship, I have one point. My only submission is that if we calculate and deduct the 5 lakhs amount, there will be below 3% of DA amount, your lordship, which makes no DA case, your lordship. And as to that, I have a relevant judgment of the Apex Court. Your lordship, kindly.
Let us be clear about the fact. This property, 5,58,000, which is included in your asset list.
Yes, your lordship.
This property belongs to some Brindavan Pike Rai, isn't it?
That's a plot.
Plot.
That's a plot. Belongs to Sailesh Pradhan.
Sorry, Brindavan Pike Rai sold it to Sailesh Pradhan.
Yes.
And that is in the year, which year is that? This 2001.
2001, your lordship.
What is the check period?
Check period is 96 to 2004, your lordship.
2004.
Yes, your lordship.
And how the prosecution tried to link you with the said Shailendra Pradhan. Show me that. Is there any evidence they brought on record to show that the Shailendra Pradhan is related to you, or the money, this property purchased by Shailendra Pradhan is given by you? Something or that, so some link must be there. That is how that 5,58,000 is taken into consideration. Show me what is the evidence the prosecution is relying upon.
Your lordship, as of now, I'm having no evidence to that, but I'll come up with that, your lordship. I'll come up with that. But there is a proof that that property doesn't belong to the petitioner. And nowhere the property.
That's the apparent, because the property belongs to some Shailendra.
Yes, your
the sale deed is there.
Yes, your
the prosecution is relying upon. But how the prosecution is trying to link you with Shailendra Pradhan? That's what
I'll come to that, your lordship.
Yes, Mr. Das. This is the long and short of the matter. 5,58,000 rupees is taken into account of the disproportionate. If that is taken out, then it falls down to 3 costs. But the Shailendra Pradhan property is taken into consideration. How you are linking Shailendra Pradhan with this man? What way? Whether this property sale consideration given by Shailendra Pradhan to purchase the property flowing from his account. And whether Shailendra Tiwari's statement under 161 you have recorded? Yes.
Was different person or the family person, but that is because of the money coming from the name.
Unless you link Shailendra Pradhan, then perhaps she has a case.
My learned friend also verified the judgment of the Supreme Court. Now, this is the case for this particular contention with learned friends. At least can be a different Supreme Court. It requires
she has a 2 point. One is FIR registered in 2004.
Yes, sir.
2007 charge sheet is filed. Nothing is happening today.
The data is attributed to whom that has to be.
That you have to tell.
Second point, with regard to that will reduce to 3% in lieu of more than 10%, because that 10% is the benchmark. Now, I'm not like the calculation. Should the trial courts of this court delve into matters to find out what is the exact calculation I chartered accountant knows. That's another point, my learned friend also verified. The friend of Supreme Court is.
Yes, the 482 court are not to evaluate the evidence like a chartered accountant and all.
Volume 6, SCC, page 768.
Just a second.
2023, volume 6, SCC, page 768. State of Tamil Nadu versus R. Sundarsam.
Okay.
Just verify paragraph 81. There also before here, the High Court has acted completely beyond the set parameters I've discussed above, which govern the power to discharge the accused for the prosecution. The High Court would be said to have blown the role of a child. What we expect our court to do to find out what's the calculation. And if the calculation deducted, this is added, this is deducted, then it comes down to 3%. This is also anyway, just very
This exercise you do it.
Yes, Your
This
Lordship.
exercise, but at the same time, you have to link Sailendra Pradhan with this petition.
Yes, Your Lordship.
Yes. I'll put it with you. You are arguing or Mr. Marana? He will be coming when? Huh? First week April.
My lords, can it be on 24th next week?
Why Mr. Marana has to be there? Keep it on 24th, we'll see. 24th. Because there is very small matter. If that Sailendra goes, then see the case. You just check it, even if.
Sailesh Pradhan.
Sailendra Pradhan.
Sailendra Pradhan. That.
Yes. 24. Yes.
Grateful, Your Lordship.
Last order in Los Angeles City, 19/2/2025. I have given the judgment and I have filed the case on the ground of jurisdiction. On the ground of jurisdiction.
Jurisdiction.
Yes, yes. Who judgment? On that.
Why Abraham?
Why Abraham?
Already overruled, man.
Sorry?
Why Abraham overruled? Yes, kindly. Rupali Devi. Three judge.
Let me refer. But maybe the judgment is referred to last time.
Who did you? I have to verify.
The judgment has referred. Well, there is a referred.
Para 16.
Yes. Para?
Last.
16, 1/6.
8 is also 11.
The ratio.
Minor.
But I have to verify because this is not specific element. The entire occurrence took place within the jurisdiction.
But how will you get out of it?
That I have to verify.
That
Because
Abraham already overruled.
last line it has been stated. The home account
Also have jurisdiction granted in the company.
ଯଦି link କରୁଥିଲେ କିଛି ବି ଗୋଟେ part ହେଇଥିବ ତାହେଲେ ବି
Not necessary. If you have committed the cruelty here, and as a result of which she had to move to her parents' house, somewhere in UP or wherever, the UP court assumes jurisdiction. That's what.
But I have to verify this. I have to verify.
Directly against your.
Yes, yes. I will.
Cruelty is a continuous.
Yeah, that everybody knows. Cruelty is a continuing offense.
Yes, yes.
But whether that is almost to
See,
the situation will
see if you force the lady to leave your company and goes to her parents' house.
Yes.
And she is staying there, parent house, the offense is being continued there. Because it's 498A.
Nothing.
Even if mere presence, her presence, mental cruelty is inflicted every day till you resolve it. So therefore, the jurisdiction.
So that act drove her out and staying in her
do you have any other point or only jurisdiction?
On the jurisdiction ground, I have.
But now, on that basis, I'll dispose it up.
No, my lord. I have to verify because whether this is, my lord, entire thing I have to collected, my lord, this is, everything has been discussed in the decision. The conclusion part is there. But I have to say whether entire thing has been taken note of or not.
The counsel for the opposite party has relied upon the judgment reported in
My lord.
so and so.
2019.
5 Supreme Court cases.
And it submits that which court is that taking cognizance? Which court?
Here, my lord,
Court of who?
Ranpur.
No, cognizance taken by
Kendrapada.
The Stations Court Kandrapada, which has taken the cognizance of the offences by the impine order and jurisdiction to entertain the complaint. Mr. Maharaja, appealing for the petitioner, seeks an adjournment to verify this adjournment to address the court on the next appeal. Please the matter on substance. Entry want to continue.
99. Entry want to continue.
Yeah, I have recorded here.
99.
May I please, my lord? My lord, these challenge filed by both accused petitioner and victim. Date of accused petitioner or victim. Date of action both are measured.
Service.
Notice is routine in the served.
Service.
See, nobody has come, my lord.
Huh?
Informant has not come, my lord, and the case diary is also.
Informant has not come, but it was directed that it should be served through the IAC.
That the victim as well as petitioner to the court.
Have you got instruction?
Case
So they
diary is
served
also
or not?
required. No, my lord. Case diary is also required.
Date of occurrence both are measured.
ସେଇଟା ମାମୁଁ ଦେଇଛନ୍ତି ତ informant ମାମୁଁ ବାପା
Victim as well as accused petitioner both are present in the courts.
On 7/3/2025, the IIC Jajpur Road Police Station was directed to serve opposite party number 2. The State
Madam,
Council has not
kindly-
yet received the instruction in that regard.
Kindly CD may you call for,
Please
my
the
lord,
matter.
because 164 is irrelevant.
Leave the matter on second Thursday, the interim order to continue.
Interim order continue, my lord.
Yes.
It's interim order continue.
Hearing matter. Let it be there. Let the hearing matter be there and let there is some solvable problem.
27 days are the Passover matter.
Which Passover?
Item 27. Item
Adjourned.
number of cases have been allowed.
But nobody came, then what to do? Second call, nobody came. Tomorrow, not tomorrow. Already, let's see whether I've signed the order or what. Huh? Order has already passed. If I have not signed, just take it up. 27, no? 27 item. Not tomorrow, but next week.
My lord, item number 117, I have been dismissed from service for 8 years.
I
And
have
the
not-
money was never
This will
recovered from
remain-
me.
This will remain in the list.
My lord?
Because there are some server issue and all, I will not take it. Take up.
I mean, pardon, my lord, item number 88. It will be taken up tomorrow or day after or next week.
No, he will give a date.
The interim order is
Interim
there.
order will continue. Interim order.
Item 67, my lord. In item 67, petitioner had sought to withdraw.
I have exhausted the list. Now reverse way again, I'll take a what?
No, my lord.
From 1 to. You're not there, then I have passed the orders. I might have signed the orders also. Reverse way don't do.
That was delivered.
The rest of the matter, let it be there. Because there are survey issues, not.
My lord, a part heard matter is there, your lordship, item.
All the matters will be there in the list. Tomorrow I'll take it up. After 100 onwards.
Let me